Item number 3, my lord.
Item?
Item 3. I don't want to press this written as per the instruction of the client. And what is number 1?
Is there a stay?
No, no stay.
No stay. The stay capable said the learned counsel appearing on behalf of the petitioner means that he has instructions to withdraw the instant petition. Accordingly, the instant petition stands closed on withdrawal. The equal appears on behalf of the respondent.
Okay. Okay.
My lord, in item 52, my lord, we have filed an affidavit as lordship directed us, which is not on record, madam. That will be possible. Lordship,
That
My
is
lord,
that matter, no? That matter where you want to construct.
yes,
You want to construct.
directed us by an undertaking in the form of affidavit.
my lord, item number 31, my lord. We have already compromised. Put between wife and husband. Paid for transfer from Jorat to Galpara. We have already compromised.
There's a stay.
Lordship?
There's a stay.
No, no. If it is there, it may be taken.
No, it can't be vacated like that. I have to direct both the
Transfer
parties
petition.
to appear before that court. Huh?
Lordship?
I have to direct both the parties to appear before that court. Because there has to be, there is a stay, no? Mr. H. Dust, the legal counsel appearing on behalf of the petitioner, submits that
No stay over
he has
there.
instructions to withdraw the instant petition. Ms. P. Bhattacharjee appears on behalf of the respondent. Taking into account the above, the instant petition stands closed on withdrawal. The interim order stands vacated.
T523. T523.
P523 stands vacated. Dated so passed by this court, dated 358 stands vacated. And the parties who are duly represented are directed to appear before the learned trial court on 21st of April 2025.
Okay. I would like. Hello.
For motion item 1.
What is this?
Last occasion, actually, I was asked to go through the evidence because trial court has observed that the statement as regards their possession was made on the basis of documents. In fact, I have gone through the evidence and it was and he has made those statements which are prior to his birth, those statements based on documents which were prior to his birth. That cross examination is there, I was born in the year 1987.
There is a defendant.
Yes, defendant. I'm for defendant.
I'm not for the defendant, I'm for the plaintiff. Plaintiff, the suit has been decreed.
Yes,
So what is, this is a section 6.
section 6.
Section 6. The question is as to whether he was there prior to 6 months.
6 months.
That's
Yes,
the question.
The second page,
Of
cross examination second page, Relief House, second page.
whether he said.
Last line, it is not a fact that I have been in possession of the suit land since the year 2019 only. Below their case is that I am from 2019 and suit was filed 12/10/2020.
No. Not him. Yeah.
Can you have a look at that last suggestion? It is not a fact that I have been in possession of the suit land since the year 2019. This suggestion was put below.
Where is the chief of the plaintiff?
Yes, plaintiff.
You did not put even a cross-examination into the petition. Who is PW2?
PW2, his brother. The plaintiff's brother.
Who is this Amarjit Kaur? PW2.
PW2.
How can he be brother? Daughter of Bhuta Singh and you are saying brother. PW2 is the daughter of Bhuta Singh. Here, plaintiff's case is that in the month of June 2020, the defendant most surprisingly stored sand and rocks by occupying over a portion of the land measuring 1 bigha 7 katha so and so described in Schedule B. And then it was filed on the month of
Month of
July.
October.
No, July.
No, that is the amended one. That is
What?
that is otherwise October.
It was filed in the month of October
2020.
2020. So,
And in suggestion, they have put me on that I
no, it's
have
okay. Forget about their suggestions. Our suggestion has nothing to do.
that is
But
admission.
where did you put the cross on that? The chief. This is the most important thing is that where why you are going into the defendant's evidence? I'm not concerned.
Yes.
I'm concerned with the plaintiff evidence. Where's the plaintiff evidence? Ah, got it. Paragraph 13 of the plaintiff evidence. That in the month of June 2020, the defendant most surprisingly stored here and this is how Schedule B comes into the picture. He files in the month of October, which comes within the period of 4 months. Now, there's not a single cross on this point. Mr. Sahu, nothing is happening.
But
The better off. Let this matter be listed on 2nd of April.
otherwise I'll be addicted. Problem is that.
You see,
Otherwise, we don't get to that trial court has not come to the finding, specific finding as to where they were dispossessed. Garnet trial
why
court
did
has
the
treated
trial
this
court spend so much of time on these unnecessary things?
as if it were a regular suit.
Regular suit. Well, no, because you have, the plaintiff have also asked for confirmation of possession.
Yes.
How can we be a confirmation?
That is where we know. If your lordship
Well,
come,
file within the- Now, what does issue number 2 say? According to the plaintiff, she was dispossessed from the suit land in the month of June 2020, and the instant suit was filed a year. On the other hand, defendants have pleaded nothing as regards the period of limitation. As such, it is held that the suit is filed within the period of limitation, and accordingly, issue number 2 is decided in the affirmative.
in there below section 6, the main issue is below Yes.
Possession prior to
prior to
6 months.
within 6 months. That is the main issue, my lord. But that was not discussed with reference to the evidence, my lord.
Issue number 4.
Issue number 4, if your lordship comes to the
These are all the few.
at page 46,
Let the four independent stands in the suit.
ultimately,
Before. Yes.
because my entire case was disbelieved because I could not prove my documents, as the documents were not registered one. As if
But you did not cross-examine the defendant on this point.
otherwise I am rebutting by adducing my evidence.
What evidence did you say that you were there?
Yes, since 1964 I am there.
No, you are saying that you were since 1964.
Yes.
Let us see the cross-examination of yours.
Yes.
Who is Gajanan Sahu?
Gajanan Sahu was my father and Umasankar was my grandfather.
But you did not cross. There's not a single whisper in your evidence. Even suggestion is not there. Here you put a suggestion. It is not a fact that the predecessor of the defendants have been continuously paying the land revenue in Israel and now the defendants have been here. It is not a fact that after the purchase of the said land, Umaso was in possession of the land and after his death, his son was in possession of the land. Presently, the defendants are in possession of this land. I have deposed fully in paragraph number 9 to 17 of my affidavit in evidence on affidavit. It is not a fact that since the date of the purchase, the land measuring so and so out of the total fruit land has been continuously in possession of the defendant.
Suggestion was there, my lord.
That suggestion is not there, na?
Because
For a section 6, the suggestion should have been in the month of June, whether you were outside.
because I have, suggestion was said that we have been in possession. That, second, third paragraph. Married that. It is not a fact that on 8/6/1964, Kumar Singh had sold an area of measuring so and so out of the total suit land to the defendant's grandfather, so and so. It is not a fact that the name of the grandfather's Kumar Shankar Sahu was not inserted.
Different line, everything.
It is not a fact that after purchase of the said land, Kumar Shankar Sahu was in possession of the suit land, and after his death, so and so in his possession of the suit land, and after his death, his wife and defendant's mother, so and so was in possession, and presently the defendant are in possession of the suit land. That suggestion was there.
Hmm.
And presently the defendants are in possession. That suggestion was there.
Now, if these two findings are positive, whether the suit has been filed within the prescribed period of limitation, you did not raise that.
But first of all, the date of disposition has to be, court has to come to a finding on which date you were dispossessed. That the very vital thing was not, decided by the line of trial court. And the entire suit has been treated as if it were a regular suit.
So file appeal.
Milord.
I will pass this order. Say that this is, the court has in fact gone into various aspects, so this may be treated as a regular suit and he will file appeal.
Milord, then the order itself is a nullity because court doesn't have jurisdiction.
Why?
Section 6(5) court,
Do you put out there, you have filed a plaint under section 9 of the CPC? No, I'm asking you for a more added clarity. In a plaint, do you put it that I am filing the suit under section 9 of the CPC?
it was not. No, otherwise regular suit comes under section 5. Regular suit comes under section 5 and that procedure is different. And this is summary procedure, madam.
What is the summary? What has happened here? He is asking for confirmation of possession. A recovery of possession, section 6 is only a recovery possession. But he is also asking for confirmation of possession. Meaning thereby what? Maybe the suit may be bad because there is no question asking for the declaration.
But then title has to be decided. The title was not even decided. The
I'll
ultimate
call for
dispute of section 6.
I think one judgment has to be delivered as to how section 6 proceedings are to be dealt with.
Yes, that is required.
You are very happy with that.
No, otherwise, because this
A
concept,
section 6 proceedings, a judgment of 21 pages, 29 pages. What else can happen? The plaintiff is entitled to confirmation of possession. How can there be a confirmation of possession being given in a section 6? And there is no finding now on which date it has been made. Heard Mr. S. Sahu, the learned counsel, appearing on behalf of the issue notice, making it returnable on let me come back and complete on 7th of May 2025. Steps be taken by way of registered as well as usual. In addition to that, you want to stay? You want to stay? In addition to that, the petitioner is further directed to take steps upon the respondent number 1. Others not required. Now, you take steps as regards by registered as well as usual upon everybody. But as regards respondent number one is dusty. Number one, dusty and file an affidavit of service on. This is an application filed under section 115 of the Code of Civil Procedure, challenging a judgment and decree dated 30/10/2024, passed by the learned court of the civil judge, Junior Division, Gopur, Viswanath, in title suit number 02/2020, whereby the learned trial court decreed the suit in favor of the respondent number one herein, who is the plaintiff. It is relevant to take note of that the proceedings being title suit number 02/2020 is the proceedings under section 6 of the Specific Relief Act 1963. In a suit pertaining to coming under within the purview of section 6 of the Specific Relief Act 1963, what is required for the learned court to look into is as to whether the suit, whether the person concerned, whether the person, the plaintiff, was dispossessed within 6 months from the date of filing of the suit without following the due procedure of law. Although in the impugned judgment, there is a mention that the suit was filed within the period of limitation. But while deciding the issue number 4, there is not a single whisper as to when the plaintiff was dispossessed. Considering this vital aspect having not been declared by the learned trial court in its impugned judgment, this court is of the opinion that this court is of the opinion that the impugned judgment and order dated the judgment and decree dated 30/10/2024, passed in title suit number 02/2020 by the court of the civil judge, Junior Division, Gopur, Viswanath, is required to be stayed till the next date. Accordingly, it will stay till the next stage. Records not necessary.
So the evidence,
You have it. Okay, call for the records. Records necessary. Because that is the single point. This is a case of remand. Anyways, call for the records and give it to him. All this. Oh, you do one. Call for records one. Mr. S. Sahu undertakes to file a paper book of the evidence before the learned trial court.
in this case, the conducting advocate was going to file first appeal. He was also in impression that first appeal is denied. So that is when
No, it won't lie. Means the court has made the mistake. Yesterday there was one matter the court had made the mistake for which I had to frame a substantial question on.
Or at least on item 2.
What is this? We are challenging.
I am the plaintiff tenant and the opposite party is the landlord. There was an agreement for tenancy agreement, my lord. I paid advance amount of rupees 2 lakhs. And the terms was they will construct the house and give it to me for doing my business. And they took the money but did not make any construction, neither made construction nor delivered possession. My lord, because of this, my lord, the suit was filed. Suit was decreed. Then, my lord, I filed execution. They filed an application under section 47, alleging that the period of tenancy has expired for 5 years and it has expired So decree has become inexecutable. And
Huh?
decree has become inexecutable.
Why?
They say that the tenancy was for 5 years and it has expired in the meantime. So my lord, decree and execute.
What was the decree passed?
Decree, my lord. And the operative part is at page 44.
You are the tenant.
My lord, I am the tenant.
In view of the above discussion and so and so, it is hereby directed that defendant will hand over the possession of the suit premises to the plaintiff, and the plaintiff shall occupy the same as tenant in accordance with the terms and conditions of the agreement. You were evicted?
No,
What is your suit for?
possession was never delivered to me.
You are the plaintiff.
I'm the plaintiff.
Defendant who also is the landlord in the respect of tenancy is still incurred in the tenant. So you entered into an agreement that you will pay 10,000 per month. You'll pay 10,000 per month and you paid an advance of rupees 2 lakh. With an undertaking, then when she builds a particular construction, you will be given at a room. That is the agreement.
That was right.
Now, for that, what did you file the suit for?
Food for my lord, the construction of the shop premises and to deliver possession.
So it's just more like a suit for specific performance. It is a suit for specific performance.
Dictate, my lord. Possession was never delivered to me.
No,
For-
isn't
for-
it? No,
for
you.
for enforcement
No,
of the
no.
agreement.
She was your landlord. Then you entered into an agreement to the effect that you will be paying 10,000 for the newly constructed room and you paid an advance of rupees 2 lakhs. Now, they did not deliver the room to you. They even did not go ahead and construct. So you asked for a decree for what? Specific performance.
That's the person.
It is essentially a decree for specific performance. Now tell me whether the building has been constructed.
In the meantime, I have to take instruction of what.
Not necessary. As on that day, was it constructed?
No, it was not constructed.
So nothing.
As on that date, it was not.
Your aggregation petition is bad. Right, please? That is the problem.
Not new construction, my lord. There was a house. It was to reconstruct only.
No, you. Therefore, it was a suit for in view of the above discussion. In one, it is hereby directed that the defendant shall hand over the possession of the suit premises to the plaintiff, and the plaintiff shall occupy the same as tenant in accordance with the terms of the agreement.
Fine.
Now, the agreement is only for this purpose when she constructs. But if she has not constructed, how can there be a decree?
Not construction, only, it is only agreement to make three minutes, it is executive form, my lord.
Let us see how does the trial court executing court look into it. And I find it in the light of the specification of law, the decree the suit, I don't agree with the opinion there. But let us see the agreement.
Yeah.
Now, have he paid back the 2 lakhs to you?
Yes, yes.
Huh?
No, I paid to you.
Have you got the 2 lakhs back? Have you filed this agreement out here in this proceeding?
Yes, exhibit one.
Yeah.
Yes,
In this
but
court.
I have not annexed it. I have not annexed it. But
No, you bring it. Because without this, I can't. I think what order can be passed is, see, the sum of the terms of the agreement is, yes, this agreement may be for a period of 5 years, but they have continued, they've taken the amount of rupees 2 lakhs, which is the finding of fact arrived at. Now, they having not handed over the possession, which was decreed, the executing court could not have gone beyond the decree to say that it has been in. This is the order which I propose, but without this agreement, I can't do that, you know. When? Because like record everything. Record everything. Either you file a call for the record, the recording calling for this make good sense. Record is called. Record this document is there. You do one thing, I let me call for the record and also bring this document by way of an affidavit. Oh, very. I do go ahead, you see. Mr. Heard Mr. KKD, the living counsel appearing on behalf of the petitioner. Upon hearing the matter at length, this court is of the opinion that for the purpose of effective adjudication of the instant proceeding, the records of title PX and title execution case number 02 of 2016 would be required. Accordingly, the registry is directed to take effective steps for calling for the records of title execution case number 02 of 2016 pending before the, it's no longer pending, na? From the court of the learned civil judge to be and place the same before this court on the next date. So fix here in under. So in addition to that, the petitioner is also directed to bring on record the affidavit on the basis of which the agreement dated, what is the 17/2009, on the basis of which the decree was passed in title suit number 37/2011 by filing an additional affidavit. This court fixes this matter on 19th of May 2025. Pusto.
Item 4.
What is the matter about? What are they challenging here?
Challenge lordship, they are suit lordship. They are subsequent suit lordship. They are state lordship.
Huh?
Our suit was filed by me lordship of the trial court lordship. Subsequently, they filed another suit lordship. On the same ground. And that is state by the court. They challenge it. In between lordship,
So they are
there
challenging the order of 18/9/2018.
There is the last previous lordship. Whereas both the parties second lordship, I mean, first suit lordship, that is of the closed lordship.
And where is the first suit? First suit filed where?
First suit was filed lordship and that is. Filed on 2nd of March 2017 lordship of filed lordship.
Is it before the same court? No.
So the court is different lordship. They filed this with the lordship.
There is a state. There is a stay to this order. No. What has happened here? Now your suit is proceeding.
My, now it is closed lordship. On the basis of this agreement, settlement lordship, my suit is closed lordship.
What happened?
Yes, settlement lordship.
Matter has been settled.
Settlement lordship. That's technically their lordship.
Oh.
Their lordship, they want to do this matter lordship, but council is their lordship now.
Your suit has been withdrawn.
Yes, closed, because they disposed of lordship on the basis of the agreement, closed lordship.
So there is a compromise decree.
Yes, sir.
Huh?
Yes, sir.
Where is the compromise decree?
Closed order is their lordship. Is their lordship. Yes, sir.
None appears on me. There is a compromise decree.
Yes, yes, lordship. Arts of lordship, there is also closed lordship. Alright.
None appears on behalf of the petitioner on call. Mr. So-and-so appears on behalf of the respondent.
One is-
It has been submitted by. Pusto. This is an application. The present proceedings have been initiated for challenging an order dated 18/9/2018, whereby title suit number 41/2017 was stayed by the court of the learned civil judge Kamrup Aminga by in view of section 10 of the Code of Civil Procedure 1908. The learned counsel appearing on behalf of the respondent submits that nothing remains in the instant proceedings, taking into account that title suit number 13/2017, which was the previous suit, have already been settled by way of a compromise. And the compromise decree and the mutual agreement on the basis of which the compromise decree was passed was placed before this court. The same are kept on record and marked with the letter X and Y. So taking into account the above, nothing further remains in the instant proceedings for which the instant proceeding stands closed. In terms with the compromise. Date to sign over there.
Item 5 and 6.
Matter may kindly be taken up at 2.
Why?
English council say the next vote number 2.
Who?
R Hussain. R Hussain.
R?
Hussain.
R Hussain is where?
Next vote number 2.
Vote number 2. Okay, you argue. Well, what is he challenging?
I am the landlord. The plaintiff is the landlord. And I have filed a petition against the defendant. Against the defendant. And trial court has issued the suit in my favor in favor of the plaintiff. And the first appeal court also found the judgment degree. So against that, let's file it. And I don't like it. Proceed also. I filed one civil petition about first appellate court order, my lord.
You have challenged.
My lord, in the particular challenge.
Why both are fine?
Yes. In the judgment by case, I was ordered for compensation amount.
Huh?
Compensation was awarded in favor of the plaintiff of rupees 2,000 per day by the trial. But the first appellate court, my lord, without recording any reason, my lord, has reduced that amount to 500. That against that teaching order, I have challenged one civil.
And this is bad on both counts.
I'm challenging that compensation part of it.
No. Is it bad on both counts?
Yes. All the both in trial court as well as the appellate court were decided in my.
And both means defaulter and heir.
Yes. Folder and for eviction. It is for eviction. As well as declared in that folder. My lord, maybe come to page 45.
Mr. Counsel, tell me one thing. Are these people, this Bhupesh Borua, that they had some hotel? Oh, I won't take it up then.
Okay.
Otherwise, this should have they dismissed. This is the matter with any other courts.
Okay.
7.
May please, your lordship.
Yes. Who are you?
Lordship, I am for the appellant. Lordship, the case is about I have a development agreement. I am a landowner and an LOT. I have entered into a development agreement with the respondents, and subsequently, I have also entered into an allotment agreement by which my land was given to the respondent, and in exchange of the land, the respondent has promised us to give flats and a commercial space, Lordship. Thereafter, Lordship, there was an allotment agreement were given to me by which the flats were allotted to me and a commercial space were allotted to me. However, there were some deviations in the commercial space, and your Lordship, this whole land, these whole flats was a part of a larger project called Horuguri complex. Now, Lordship, as per the agreement, allotment agreement, the respondent and as per the whole project, the developer has not completed the works, and there are certain deviations in the works, due to which I had filed a complaint before the Honorable RERA authority. However, and subsequently, the RERA authority has also called for a status report. The status report has also highlighted the deficiencies that has been committed by the developer, which is the respondent here, and also their application for occupancy and the completion certificate was rejected by the municipality board or the registered authority. But the learned appellate tribunal has gone into the view that I have, on the point of locus, that I have not been able to show violation of any provisions of the Act. However, my lordship, I would like to place that my grievances are squarely covered under section 14 of the Act and section 11(4)(b) of the Act, because his completion certificate was rejected by the Honorable RERA authority. Lordship may kindly have my complaint, my prayers in the complaint.
Is the impugn order? Impugn
Lordship at page 155.
Page
155.
two appeals you filed. Who filed?
There were two appeals that were filed by the respondent.
What is your name? You are Prasanta Bachchan?
Yes, dear Lordship, I am Prasanta.
बहुत फंड
Lordship, the first appeal was against the order of 23rd of April, in which the issue of maintainability was decided, and the second order appeal was against the order of 2nd July, in which direction was passed to the respondent to complete the commercial areas, hand over the commercial area.
You are the landowner also.
Yes, Lordship, I am a landowner also, and also an LOT, Lordship.
You are also a LOT.
Yes, sir.
So what is your case?
Lordship, my humble submission is that I am an LOT as per the Act, and there has been violation, and as per
Has there
the
been any allotment made in your favor?
pardon, your Lordship.
Has there been any allotment made in your favor, or is it just the development agreement?
There is an allotment letter, Lordship. Like, Lordship, may kindly see the allotment letter. There is an allotment, Lordship, there is an allotment agreement, and there is an allotment letter also, your Lordship, by which the flats were allotted and commercial space were also allotted, your Lordship.
Now, what is your question of law?
Lordship, may kindly have page number 19. My question of law is that, Lordship, the learned appellate tribunal has failed to consider that there is a specific violation of section 11(4)(b) of the Act and section 14(1) of the Act. Because the learned tribunal has based his observation on the point of locus that there has been no violation of the provision. I have not been able to establish any violation of the provisions of the Act, your Lordship.
No, the learned appellate court,
Yes,
appellate tribunal had come to a finding that yes, you may be a person aggrieved,
yes, Lordship.
insofar as the instant, no, he said that a person, a landowner can also be a person aggrieved.
Yes, Lordship.
But so far as the violation which has been done
Yes, Lordship.
comes within the ambit of the development agreement entered into between the builder and you,
Yes, Lordship.
which does not come within the purview of the RERA jurisdiction. And as such, you are not a person. Isn't that the finding?
That is,
Reading the entire thing in 2 or 3 sentences, that is the finding.
yes, Lordship. But
So what should be the substantial question of law?
Lordship, the finding.
I'm going to admit it. The
Yes.
question is, what is the substantial question of law?
Lordship, apart from the development, the learned appellate tribunal has overlooked the development, the allotment agreement and the allotment letters that has been issued in favor of me, Lordship, in exchange of the land, your Lordship. And it had, and Lordship, my humble submission is that this particular multi-story building that
So
was
your
developed.
substantial question of law should be that whether the judgment of the learned trial court, first appellate court, suffers from perversity in not considering that there were, in only considering the development agreement, but not the allotment letters.
Please, Lordship.
Is that the
Lordship, apart from that also, Lordship, there is apart from that also, Lordship, the learned tribunal has also, in the finding, has observed that I, as a landowner, there is no locus because I have failed to show any violations. Though I am an aggrieved person falling under definition of section 31, but I do not have any locus to show that there is any violation of the provisions of the Act. But Lordship, my humble submission
because
is
of the development agreement?
because of the development agreement. Yes,
But
Lordship.
the fact that you were also an LOT
Yes, Lordship.
and thereby coming within the purview of the person aggrieved.
Yes, Lordship.
As such, if there is any violation to section 14, 11, 4D and 11, 4F,
Yes, Lordship.
the learned and read with 17, the learned trial court, appellate court to have looked.
Lordship.
So let us admit it with one question only.
Lordship.
Okay?
Lordship.
Heard Mr. So-and-so, the learned counsel is hearing on behalf of the appellant. Appellants, this is the appeal filed under section. What
58,
section?
Lordship.
Huh?
58, Lordship. 58 of the RERA Act.
58. 58 of the RERA, Real Estate Bracket Regulation and Development Act 2016. challenging the order dated
1927.
judgment and order dated 19/12/2024. You have filed only one appeal.
Lordship, it's a common appeal, Lordship.
How can there be a common appeal?
Because Lordship, it was a common judgment, Lordship.
No, you have to file two appeals.
Lordship, by the
So
impugn,
if you have not filed the other appeal, that means it has become final. No, you can't file one appeal. There are two appeals.
yes, Lordship.
You
But-
cannot challenge by only one appeal.
Lordship, but the two appeals were disposed of by the common order.
So what? I mean, to dispose of pass one order for both the appeals. That is a different thing. But
Yes,
that
Lord.
doesn't mean that you are going to file only one appeal. On that ground, I can't admit it because it will be a conflict. Because in one case, you are already held to be a person aggrieved, not a person aggrieved. And if I admit this, you are a person aggrieved. How do I pass a judgment in this case? File another appeal.
Yes, Lordship.
It's the matter after 2 weeks.
Yes, Lordship.
Filing.
Obliged, Lordship.
Item 8.
Yes.
It was for a specific performance of content, my lord.
What are you challenging?
Along with an injunction application was filed at the very first stage
Oh, notice was issued only.
of
It should be interfered.
my lord, next date was 7/4, my lord. Moreover, if your lordship come to page number
What
1,
happened on 7/4?
it was moved on 6/2, my lord.
So,
Here the transaction of more
you
than,
are approaching now here.
no, we have filed already, my lord.
So, why should
Immediately.
we?
My lord, in the meantime, any third party right may be created, any agreement, they may come out, because we have paid around 75 lakhs of rupees. In every transaction, there is an acknowledgement. The agreement itself is a, my lord, registered agreement. If your lordship come for a time being, my lord, page 151.
So, when did you file the suit?
It was filed, my lord, 1/2/2025, my lord.
Yes. And he had returned you the money in 2023.
24, my lord.
23.
24, he has given me the, my lord, 6.
No.
Yes,
It is recorded in the order. When did you get the money? 24.
no, my lord, he didn't get the money, my lord. He has paid the 6.
He has returned the checks. He had issued
He
checks.
had issued the 6.
And you did not
That
accept
check
it.
has been on, dishonored, my lord.
Check has not been dishonored.
It has been dishonored, my lord.
How do you know?
My lord, we have presented the 6 before the bank, my lord.
So you have deposited the checks.
Yes.
Then
My lord, how can it be? Had the 6 has been honored, my
the
lord.
moment you are depositing the checks, you are by your conduct, you are saying that no. We have to hear the
No, no,
answer.
my- Just for a minute, my lord.
We can do one thing. We can issue notice. Appeal admit notice. Nothing remains. We'll go for another 10 years.
But only for a minute.
No. This court is not going to entertain this. The moment you have deposited the check means you have accepted it.
My lord, that has been dishonored, my lord.
Understood. Very good. This dishonored now but can you ask for specific performance?
That gives a different cause of action which will relate to criminal proceeding, my lord. Not
That
just
is
civil. my
a
lord.
different thing. But the question is, the moment they gave the check and you have deposited means you have accepted it.
My lord, it's
You
a
are-
registered
Means
agreement.
you are not ready and willing. The most pertinent thing is readiness and willingness. Where is your readiness and willingness?
My lord, once it has been dishonored, we are left with no other alternative, my lord.
For what? The alternative is to get the money.
My lord, rightly or wrongly, here's a register agreement. My right has already
Section
been
50
created, my lord.
Section 52 will hold the thing.
It will come unless and the instrument is, my lord, not cancelled by way of it.
We have approached this court very late. You filed well, 21-2. Why the matter has not come up till now? You have not put legible copies, so and so, and you cleared it on 6/3/2025.
Only, my lord, at least, my lord, let me take the service to dusty service also, my lord. Because it's around the tune of 75 lakhs rupees, my lord. Hard-earned money, my lord. In the meantime, any third party right created, again, there will be a multiplicity of
You
petitions,
therefore
my lord.
want the
I'll
money
be
back.
left to know.
No, you therefore want the money back. Hard-earned money. That is why you put the check. Where is your readiness and willingness?
No, my lord, but the agreement
It's
still
the
exists, my
data,
lord. It's
this
a
is
register
not the
agreement, my
case.
lord.
This is not the case for entertaining. I can do one thing, I dismiss it, you go and file a request the court for an early thing. The court may pass some orders if you have any urgency.
If
of
it is
any matter.
dismissed at a motion itself stage, again, it will take a very, the Robert trial court will take it in some different view. Already they came into a conclusion, my lord, that my agreement has been terminated.
Yes, the
At a
trial
first-
court also says that the
Same thing
pleadings
will
of
happen,
the
my lord.
party go to show the check has,
It's
petitioner has
it's our
accepted the
pleaded
check
case,
by
my
which
lord.
the opponent returned the
The
consideration.
objection they will file,
Until then,
same thing will
it
come out.
is not a case. Tell me. What to do? Withdraw. By dismiss, it will be more better. Pace. You have to save your pace.
Order may be passed.
Huh?
Order may be passed in merit, my lord.
Heard Mr. Endeka, the learned counsel appearing on the, and asked the learned counsel appearing on the. So this is an appeal file challenging an order dated 6/2/2025, whereby the learned trial court, that is the court of the civil judge number 2, Kamrup Metro at Guwahati, did not pass an ex parte ad interim injunction against the respondent herein. It is seen that the learned trial court, while passing the said order, had duly taken note of that the checks, that an amount of rupees 75 lakhs which was paid by the plaintiff to the respondent was for as a part consideration for the as a part consideration towards the agreement for sale. Was returned by the by the respondent herein to the plaintiff or to the appellant. And this check was duly accepted by the appellant. The learned trial court observed that from the pleadings of the parties, the pleadings of the plaintiff, of the appellant, who is the plaintiff in the suit, it was seen that the plaintiff had accepted the check by which the respondent number 1 returned the consideration amount paid by the plaintiff which was akin to accepting the termination of the agreement dated 7/2/2023, and thereafter filed the suit seeking specific performance of the agreement dated 7/2/2023. It is under such circumstances, the learned trial court
Well,
was
can I
of the opinion that without hearing the other side, the respondent, it would not be proper on the part of the court to pass an ex parte ad interim injunction order. This court is aware of the fact, this court is aware that this is an appeal, that the present appeal is an appeal in principle, taking into account that this is an appeal against an order by which the learned trial court in its discretion found it proper not to pass an order, not to pass an ex parte ad interim injunction. This court does not find any perversity or unreasonableness or irrationality in the order dated 6/2/2025. It is also seen that the next date is fixed on. This court further finds it relevant to take note of that though the impugn order was passed on 6/2/2025 and the appeal herein was filed on 21/2/2025, but the appeal was filed defective and the defects were only rectified on 6/3/2025. From the above aspect, it is also clear that the appellant hearing was not showing any urgency in moving this court. Considering the above facts, this court finds no justification in entertaining the instant appeal for which the instant appeal stands dismissed. I stands also closed in view of the dismissal of the law.
only one line that we had.
No. Now, only
Six were
one more
presented,
line
they
is-
should be dishonored.
only one line is post.
But no, but we did this, madam. But six were presented before the bank and they should be dishonored. Only that line. Okay. For specific performance, injunction was granted. Injunction order is at page 73. Page 12 is the appeal.
Civil judge,
Civil Judge, Senior Division, Bombay.
visual notice, and big the appeal issue.
Press for a scale.
No.
Issue.
No. Absolutely no. How can you give it? There is a direction not to dispossess by exercising a discretion. It would not be proper on the court of this.
The only reason why I think that both the parties claim to be in possession. The court did not venture into deciding that aspect. Now, my lord, we are already in possession, according to us. Now, the apprehension is, charged with the order, they may either enter, they may enter into possession. Because that was both the parties that came to be in possession, the court did not even visit that aspect of the matter. On page 12 for a moment, if your lordship see.
You want big justice service, do whatever you like, but I'm not going to pass on this law. The suit for specific performance, you are the plaintiff.
I'm the
Who is in possession?
we are in possession. We as in defendant number 1 had already sold the land to defendant number 2 and 3. Now, my lord, plaintiff claims that he had a prior agreement and he challenges the sale deed of defendant number 2 and 3.
How did the plaintiff enter into possession?
That's what, my lord, if your lordship sees page 12 for a moment. Page 12. Based on this Kacha agreement, he claims specific performance.
And he asked for.
He can. My lord, the only thing is he'll not be entitled to 53A and all of that. And this agreement at page 12 for a moment, if your lordship see. By this, he claims to have made an agreement for a total of 1,26 lakhs. He claims to have paid 13 lakhs on the very day of execution of this agreement. Now, our category case was, first of all, this
Possession
agreement
is not there.
What?
Possession is not mentioned there.
is not even mentioned.
Then
Then we had set up a case that on that fateful day I was undergoing treatment at Negrin's, page 14. Chilo. And this agreement was apparently executed at Yogiko.
You were at?
I was at Negrin Shillong. Of course, in the OPD department, I was not admitted to it. Page 49.
Very easy to get. Yeah, I start cutting not there in the world. You may not have even gone there. You may not have till now stepped foot in Meghalaya also.
No, I'm a resident of Shillong.
Where was this agreement done?
He says it was done in Jogighopa at the Palli. Palli. Chedamari, Jogighopa.
What's her name?
Aisha Khatun.
Aksha Khatun or Aksha Khatun?
Aisha Khatun.
On the page 13.
Yes, I've seen that.
Aksha Khatun or Aksha Khatun?
Aisha. We say it's Aisha.
You find the
And she has been mentioned as Aisha at page 14 in the plain itself. Aisha.
some problem with your brain.
I was in the psychiatrist.
So your land is there.
Land is there. Para 3, last portion at page 17, for a moment he claims to be a caretaker.
When was the possession given?
As per him, my lord, page 17, he says that he entered in the capacity of a caretaker, my lord, which has been denied by all the defendants. Page 17 on the top.
They were possession of the caretaker.
Yes, caretaker.
How does the learned trial court?
It doesn't deal with that at all.
What?
Doesn't deal with the question of possession. Even prima facie satisfaction is not recorded whether.
So here he says, page 78,
Yes, ma'am.
that while on the other hand, maintaining status quo over the soup land in disposal will not cause any harm. You get the word?
Yes, but at page 79,
78.
70, but 79 operative portion says should not be disclosed.
Now, both sides are directed to maintain status quo. Last line.
Yes. Now, my lord, it is, the opposite are restrained from dispossessing the petitioner.
Understood, but then
Then
both sides are directed to maintain status quo.
Status.
Then why should I stay?
Now, my lord, your lordship is aware of that judgment where the Supreme Court has said status quo orders in such manner without determining what the status quo actually is can create problems later on.
For that, you need to go to Supreme Court for more clarification. This court is not going to stay this.
I'll take dust.
The appeal is an appeal file. The order 43 this is an appeal file. 4, read we order 43 while we challenging and dated 29/1/2025, petition 2024 by the Court of the Civil Judge Senior Division, Bonaga. Case number whereby the limit title directed both the parties to maintain status quo in respect to the suit premises insofar as possession is concerned. The appeal is admitted, call for the reports, and the appeal is admitted. Appellants are directed to service, appeal is admitted. As all the documents, all the pleadings before the learned trial court, as well as the documents filed there again. All the documents are here.
I filed them.
No, yeah, good, sir. Appeal is admitted. This appeal for final approval. When? When?
April,
April, you went so late.
my lord, can have it
On
before
let us finish it on 28th of March.
20, can it be 26th or 28th?
Too early. We are today 17, 18, 19, 98. Fantastic. List the appeal. For disposal, list the appeal on 23rd of April 2025. The appellant is directed to effect service upon the respondent by way of registered as well as usual in 2 days, within 2 days from today. By taking steps within 2 days from today. In addition to that, liberty is given to the appellant to take steps upon the respondent by way of the steel, related to the registry of this court and file an affidavit of service on of the court. Just take one of the oath to notice, making it returnable on a date to be go. Steps be taken by way of registered as well as usual upon the respondent. In addition to that, liberty is given within 2 days. Liberty is given to take steps by way of.
Clarify that it will be a status quo.
Huh?
The lordship clarify that it will be a status quo.
I've already stated on top of my piece when I admitted the.
Regarding apportionment, lordship closed all the petitions and directed us, the parties, to approach the authority for apportionment. Now, if a lordship would kindly come to your lordship's order at page 209, at page 219. From there, I'll show my lord. Sorry, 220, my lord. May I have your lordship's kind attention to page 220, para 5.
This matter I told you earlier.
Yes, ma'am. In a read petition, my lord. Can I briefly indicate the facts, my lord? What had happened, my lord, this Purvanchal Griha Nirman Unnayan Committee, they were allotted, my lord, 30 acres of land by the government of Assam. Now, there are about 300 members of this committee, and it was basically a housing project. All the members will get a flat in the constructed building. But because of the flat situation, my lord, and because of the
Oh, I remember you got some 1 crore something.
155 crore.
150 of which you had to share with somebody.
Yes, yes.
Which was, I thought that it was not proper, but if there was some agreement, I did not.
But
Yes.
what had happened, my lord? Now, there is this from time to time, office bearers are elected who represent the committee.
Now, in a meeting which was held on 2006, 5 to 2006, the then committee allotted some portion of the land to some members on the plea that they have contributed towards the cause of this committee. Now, subsequently, when the subsequent committee came, they recalled those resolutions. In any case, it could not have been because by other than by a sale or something, title cannot be conveyed. So because by way of some arrangement, it was given. Now, my lord, there is a dispute between the members of the association regarding apportionment of the compensation. Now, before the proceedings in the High Court, a suit was filed, my lord, that is title suit number 47 of 2020 by the members who were office bearer in 2000, elected in 2006. Their prayer was, my lord, that the decision which subsequent committee has taken, that should be recalled. Now, it is in that context, your lordship's observation at page 220 is very important. 220, my lord. Para 5. The petitioners in WPC number 7355 of 23 and WPC number 6254 of 2023 also claim rights over the said land settled with the petitioners committee on the basis of certain documents executed by the members of the petitioners committee. However, those documents admittedly are not deeds of conveyance or deeds of sale. So lordship has already observed this part. Now what had happened, my lord? They have, earlier there was an injunction which your lordships will get at page number 32. Huh? Page first order. 180. Like originally when this suit was filed, my lord, this is the order of injunction and the operative portion is at page number 191. Accordingly, an order of injunction, page 190.
Yes.
Para 23, accordingly, an order of injunction is passed against the OPs, restraining the OP number 125, their main agent from entering into the land described in Schedule A to J and changing the nature and character of the Schedule A land to the plots till the final disposal of the suit. Now, my lord, in view of the acquisition, all these prayers, suit itself has become infirmable. Now, my lord, while this suit was pending, another misdemeanor case has been filed, which your lordships will get at page number 192. Now, the prayer in the misdemeanor case is at page 203, my lord. It is therefore most respectfully prayed that your honor would be pleased to issue an ad interim temporary injunction restraining the opposite party number 125 from convening any meeting of the opposite party number 1 society with regard to the suit property described in the Schedule A to Z or proceeding in any manner with regard to the suit property described in Schedule A to Z herein under till disposal of the instant suit, issue notice to the opposite party 125 to show cause as to why the added plain injunction should not be made absolute execution.
With the plain?
Yes. Plain starts at, my lord, page number 15. And prayer is at page 32. Fairly similar, all the prayers have become instructions. And new body has come, they have not been made parties. At page 32, a decree of declaration to the effect that new executive committee comprising defendants number 2, 3, and 4 is illegal. Now 2, 3, and 4 is an I.
No,
And
did they-
not have authority
Did
to separate
Did
the
they
right of-
amend the plain subsequent
No, they have not.
without amending the
Yes,
plain?
subsequent, but yes.
How did the court pass this?
Yes. Because court has very, I would say, my lord, with great respect, at page 229, my lord, kindly see, my lord, as if your lordship has directed. At page 229, para 9. It is unequivocally clear that the Honorable Guwahati High Court has distinctly instructed that no compensation shall be disturbed without prior permission from the court. That is okay. Additionally, there exists an injunction order from the court against the OPs. There is none, my lord. Given the existence of injunction order and the directive from the Honorable High Court, this court concludes that OPs lack the requisite authority to convene any meeting regarding disbursement of the compensation. And regarding convening of meeting, competence of defendants to hold meeting, these were never a part of the pleadings in the earlier plain, my lord. This circumstance establishes a compelling prima facie case in favor of the petitioner. Moreover, the petitioners have challenged the legitimacy of the committee's formation, which the OPs intend to utilize to.
Why?
Because we are not praying for injunction, my lord. We are praying for stay of this order. So we have made prayer and paid extra court fee, my lord.
You have to file an
Okay,
appeal.
on Friday.
Why do one thing?
Yes. My lord, we intend to hold meeting. Let's register convene the meeting.
Okay. Let me ask you to admit the appeal and take steps by 28th of March. And that day, because the thing is like this, for me, I'll dispose of the appeal.
Yes.
The thing is, other courts may not. So that is all. Because this appeal I can very well, but the problem, one thing I see, it's of 11/11/2024. And we are in the month of March, almost ending. And it would not be proper without giving an opportunity to other side for stay. So if you can effect service
Yes.
by the state, I can finish it up.
Yes. Okay.
So that is the only way out. This has to be disposed. If I dispose it of, matter finishes. So these are matters that will take much time. And did I direct anything to the effect not
No,
to
my lord.
disperse?
Oh,
I
Not
would
at all.
have, I never would have said that.
so that's why I said, my lord.
In fact, this order was not staged for the trials.
I never said that one quite.
No, never.
As to whether the amount
Para
will be
16
paid.
page 222, my lord. Accordingly, this court disposes of the matters of instant petition, thereby granting liberty to parties herein to further proceed in accordance with the provisions of law. Before parting, this court finds they observe the delay in disbursement on the contrary, my lord, so that they don't have to pay interest. That part was also protected by your law.
I never said that.
Nothing, my lord.
That not to disperse.
This
My
order
lord,
was never
I
placed.
was told, my lord, this order was not even placed in the court.
So we do one thing, that
Yes.
is the best way out.
Yes.
Mr. K. Chaudhary, the learned senior counsel, assisted by Mr. Ajay Das, the counsel, appearing on behalf of the appellant. This is an appeal under section 104, where it is for the appeal in 1 hour of the Code of Civil Procedure 1908, challenging the order dated 11/11/2024, passed by the learned civil judge, senior division number 1, Kamrup Metro, in Miss J case number 288/2024, in title sheet number 47/2024, whereby there was a issuance, there was a direction issued, whereby there was a injunction passed, thereby restraining the appellant's hearing from convening any meeting of the appellant number 1 in respect to the property described in Schedule A to J, or from proceeding in any manner regarding the aforementioned properties. First, the learned senior counsel submitted that the instant appeal, that the learned trial court have exceeded its jurisdiction in passing the said impugned order, passing the impugned order, taking into account that the said aspects which were brought on record, on the basis of which the impugned order was passed, has not yet been brought on record in the suit by filing any amendment application. In addition to that, the injunction which have been passed in respect to the Schedule A to J properties would not have been passed taking into account that the land have already been acquired by the government. And as such, the injunction order so passed is required to be interfered with. The Learned Senior Counsel further submitted that the injunction order so passed interferes with the working of the appellant number 1. And as such, the injunction order is required to be interfered with. So taking into account the above, the instant appeal stands admitted. Admitted. The appellant is directed to appellants are admitted and first to list the matter again on 28th March 2025. The petitioner hearing, the appellant's hearing are invited to effect service by way of registered as well as usual. By registered post upon the respondent numbers 1 to 10 during the course of the day, by taking steps during the course of the day, list the instant matter. In addition to that, the appellant is also given the liberty to take steps upon the respondent number 1 to 10 by way of the still routed through the registry of this court and file an affidavit of service on it. We'll finish it off on the next. I've already indicated the grounds.
Yes.
When they see it, they will come.
11.
Yes.
It will challenge the Indian order which is 28th.
Appearing 90 days. In the said order, it has been also fixed that the written statement be filed on PEA by the performer. However, it is the case of the petitioner that the case of the copy of the claim was served on a month and as such the 90 days will expire. However, the file you received the copy on 29/6, no?
29/6.
They allow the petition. You are the performer. He is the main person.
But I have filed this.
That's it. He happens to be the main person. Performer is from number 4. Why is he so eager?
But the filed for declaration of right title on the basis of adversary. So I'm one of the daughters of my lord.
Brother?
The daughter of the person by the stage 3 by who had come in possession of the land of the license.
No, all are understood. But why the performer? Performer is so interested. Huh? You are appearing for whom? The plaintiff. But Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Mr. So-and-so appears on behalf of the respondent number. On behalf of the sole respondent, who is the plaintiff. The instant proceedings under Article 227 of the Constitution is challenging the order dated 28/8/2024 as well as the order dated 24/10/2024. Passed in petition number 15 on 2022. By the order dated 28/8/2024, the performer defendant number 14, who is the petitioner herein, was debarred from filing the written statement. And thereupon, the plaintiff, the petitioner, the performer defendant number 14, filed an application for accepting the written statement, which was also rejected by the order dated
Accepting my lord. The written statement was not filed. Again, further time was sought. That is the reason why the second application was rejected. Your lordship would.
No, you see the prayer, the petition, which was filed by the pro forma defendant number 14, Srimati so and so, praying to allow her to submit her request.
Written statement was not sought.
And another petition on 18/9/2024 for allowing the written statement to be, for allowing the pro forma defendant number 14, public the petitioner to submit the written statement, which was not allowed by the order dated 24/10/2024. The learned counsel appearing on behalf of the petitioner who is public the pro forma defendant number 14 submitted that the written statement is ready and can be filed on any date as may be directed by the court. This court duly takes note of that the pro forma defendant number 14 was added in title suit number 15 of the 2022 on 30/5/2024. Thereupon, the service upon the of the summons where thereupon the documents thereupon the plaint as well as the documents relied upon were received by the pro forma defendant number 14 on 29/6/2024. However, on 22/8/2024, the learned trial court on 28/8/2024, the learned trial court debarred the pro forma defendant number 14 of the petitioner from filing the written statement. Subsequent thereto, on 18/9/2024, the pro forma defendant number 14 filed an application to allow the pro forma defendant number 14 to allow her to submit the written statement. This petition was rejected by the order dated 24/10/2024. They were fixing the suit for framing of issues on 16/11/2024. From the materials on report, it therefore transpires that the learned trial court, while passing an order, the order dated 28/8/2024, merely discarded the petition filed by the pro forma defendant number 14 without assigning any reasons. Subsequently, the reason can be subsequently by in the order dated 24/10/2024. It was mentioned that on 28/8/2024, the period of 90 days had elapsed. Pretty, however, from a perusal of the materials on report, it is seen that it was only on 29/6/2024. The copies of the claim as well as the other documents were received by the performer defendant number 14 oblique the petition. Considering the above, and also taking into account that the written statement of the performer defendant number 14 is ready and can be filed on any day, this court interferes with the order dated 28/8/2024 as well as 24/10/2024. Insofar as debarring the petitioner oblique the performer defendant number 14 from filing the written statement. But when is the next date fixed?
Statement. It was not fixed.
As the petitioner, as well as the performer defendant number 14, as well as the plaintiff is duly represented before this court. This court directs both the parties to appear before the learned trial court on 3rd of April 2025, on which date the performer defendant number 14 shall file her written statement without fail. It is observed that if the written statement is not filed on or before 3rd of April 2025, the trial court shall proceed with the adjudication of the suit in absence of any written statement to be filed by the performer defendant number 14. Well,
Lordship may kindly see last order is 5/3/25.
Yes.
Statement was,
written statement.
yes, my lord, that I have brought, my lord.
এই মাত্র আমার এখন কাগজ ওখানে চলে গেল। Yes, tell me. What was your case out here?
But here, my lord, the deceased person was traveling in a vehicle. And my contention was that the policy being act policy,
Oh, ex-police.
he is not covered. But the Lordship wish to know the pleading of the company before the MSCT, my lord. Lordship may kindly see para 8. Other rest are, my lord.
The vehicle bearing number. So your liability is 2 lakhs.
Yes, my lord.
Okay, we admit it, stay subject to deposit of fees. You yourself say,
My prayer is that Lordship, since the policy was not exhibited before us, admittedly, my lord, the Lordship may kindly remand the matter for allowing us to.
how do I do that? There is a decree award in favor of the respondent. I have to admit it. And the fact that the policy with the policy, the question will come as regards 2 lakhs. So you have to pay the 2 lakhs because that is your admitted case. So you pay the deposit the 2 lakhs before the raise. Let them take up the 2 lakhs and remaining if I am sitting next after some time, then obviously the things will, I can finish it up.
Right.
Reports may not be called for, we can remand it.
Right.
If that, no? You filed an IA for that also, no?
Yes, sir. I have filed for IA for producing the policy of insurance before the
Is an appeal filed under section 173 of the Motor Vehicles Act 1988, challenging the judgment and order dated. Judgment and award dated 4/11/2024, passed in MSC case number 17 of 2020. The learned counsel appearing on behalf of the appellant, Mr. P. Polita. P. Polita submitted that the learned tribunal had erred in awarding that settling the entire liability upon the appellant insurance company without taking into consideration that the insurance policy in question was a X policy. And this very aspect of the matter was stated in paragraph number 8 of the written statement filed by the appellant insurance company. Considering the above, this court have duly also perused the written statement filed by the appellant insurance company before the learned trial court. Taking into account the above, the instant appeal is admitted. Call for the records. Steps be taken by way of registered as well as usual. It is the matter of the completion of service and receipt of reports. IA 41 will 5 today. Order 41 will 5. This is an application 403. It is an application challenging the application. And under order 41 will 5, the Code of Civil Procedure for stay of the judgment and order dated, award dated 4/11/2024, passed by the learned member MSCT. Damaji in MSC case number 17 of 2012, whereby an amount of rupees 9,92,200 was awarded as the compensation. The ground of objection so taken in the accompanying memo of appeal, as could be discerned from the submission made by Mr. T. Polita, the learned counsel for the appellant insurance company, is limited to the settling of the entire liability upon the appellant insurance company on the ground that the insurance policy in question is an X policy, whereby the maximum liability that could have been settled upon the appellant insurance company is rupees 2 lakhs as 2 lakhs. This aspect of the matter could also be discerned from paragraph number 8 of the written statement filed by the appellant insurance company. Taking into account that the accompanying appeal has already been admitted, this court states the improved judgment and decree award dated 12/4/11/2024. Issue notice to steps to notice making it returnable on 19th of May. 19th of May. Take the improved judgment in India dated demand on dated 4th of year passed in MSC case number so and so by the 4th of Iman, subject to deposit of rupees 2 lakhs before the registry of this court within 6 weeks from today. The claimant hearing would be at liberty to seek release of the said amount technically dealing. So notice to public liberty steps by way of registered as well as usual. Upon only one claimant, yes. Why I am putting this is,
Owner is also required,
Huh?
because
no, only for the stay.
Stay.
Stay only for claimant, 1 and 2. Huh? Only steps of all respond only 1 and 2. We don't require the others. We look for stay first. 1 and 2. Huh? Why I'm doing it? It is for the purpose of, so that the matter comes. But this is an application filed under Order 41, Rule 27. Econo issue notice returnable on so and so. Steps by way of so and so, it will retain 1, 2, and 3. Huh? 1, 2, and 3. Putting it again. Steps. Place the. It is an application filed under Order 41, Rule 27 of the Code of Civil Procedure, 1908, taking liberty from this court for adducing additional evidence. This court shall take into consideration the instant application. Now, the steps be taken by so and the respondents would be at liberty to file their objection, if any, to the instant application. The instant application shall be taken for consideration at the time of hearing of the instant application.
13.
13 lordship, there. So there, my lord, the deceased person was some government employee, my lord, and he was covered under the competent family pension scheme.
So, my judgment. You are for whom? You can't get more than that. Because the conventional hits, apart from the conventional hits, how can you get more than that?
While passing that award to judgment and also in the light of judgment notice, some paragraphs also whereby the subject that I am entitled to.
Huh?
Paragraph also.
Which one?
There are 45. There are 39 to 45.
Where?
Yes, 31.
What do you
There are
say?
39 to 45. Judgments are referred here also. Those I am entitled to.
That Sebastian Leclerc judgment, lordship.
Which one?
Sebastian Leclerc judgment, lordship has gone into it while passing the judgment.
No, we do one thing, no problem. But I have dealt with another judgment of the Supreme Court.
Lordship, that is Shashi Sharma. Shashi Sharma, lordship, I have got it.
Where's my judgment of them? I remanded that matter back,
Yes,
but here the court has decided. So I think again I have to pass the same order. Here the question of remand does not arise.
Sharma and Sebastian Leclerc judgment, lordship. Another order has been passed by the Honorable Apex Court. Their judgment I am saying, lordship.
So this is what I said also in
Yes.
my bill. So you are appealing, we allow the appeal.
Okay, that is, it will be admitted and.
What? No,
And
you will only get,
there are 38.
no, nothing doing.
Judgment was also
No,
taken
no,
because
no,
there's
no.
one person.
And this court did not look into my judgment also. Did not done. You will be entitled to, do you know what how much? You will be entitled to,
The judgment and award is 59,68,590.
how many totals? 3. Huh? Parents also.
Yes.
The parents is not 80,000. So you'll get this. 1 lakh, 2 lakhs, 2 lakhs, 2 lakhs, 44,000 plus 33,000.
Chief,
That he
I
can get
cannot
it.
submit
Ah.
something like that. There, Chief, I'm referring to Sasi Sharma's husband, Lordship. There is a observation of the apex court, Lordship. Here it goes as this way. So far as the claim towards loss of future escalation of income and other benefits, if the deceased government employee has survived, the accident can still be pursued by them in their claim under Act of 1958. So, my lord, if I'm not wrong, my lord, the future prospect, regarding future prospect,
No, I'm not on future prospect. I'm not going to give on future. I'm not on that. See, consortium, also consortium, parent, filial, daughter, whatever you mean. This is for the sadness or the feeling that a person have lost. So that cannot be equated by the payment by on account of compassionate payment of the salary. Cannot be equated. So therefore, I am only directing you to pay this amount, which I have also allowed in the earlier cases. Just for example, the
I
funeral,
was there in this case.
in that case, right, for funeral, as well as for loss of estate. Loss of estate is on a different level. It cannot be broken. So this 16,500, 16,500, and these, how much? 2 lakhs, 2 lakhs 44,000. So this is the amount which he is entitled to. They are entitled to. Nothing more than that. You deposit this amount to stay the entire thing. Although I feel that this appeal should be allowed on the first date itself. I'll put it on record, give me those check in my judgment also. And record it while admitting, so that the next judge will be easier for you. In Substitution, na?
Yes, ma'am.
Where is the paragraph?
Last paragraph. Hectic market.
Huh?
Last paragraph.
So far as the claim towards loss of future escalation of income and other benefit if the deceased employee has survived the accident can still be pursued under the claim. No, not there. But Mr. T. Gulta, the counsel appearing on behalf of the appellant. And your name?
Sure.
And so appearing on behalf of the phone numbers 1 to 4. Isn't it? Why do you need the owner and driver?
Lordship, they are not
Huh?
required one.
They're not required because your issue is only on that issue. That yet they could not have got it because of that. Yes, on behalf of the respondent, the one. Mr. T. Quinter submits that taking into account the ground of objection taken in the instant memo appeal, the name of the respondent number 4 and 5 will be struck off. The learned counsel appearing on behalf of the appellant submitted that the deceased was a pharmacist. Was a pharmacist, huh?
Yes, my lord.
Was a pharmacist. And
Adolbury PHC.
at
Adolbury PHC,
Adalbari
PHC, under Joint Director of Health Services, Mosolpur BT7.
and at Adalbari PHC under Joint Director Health Services Baksa
Baksa. So,
submitted that the deceased expired on when
17/6/2018.
17/6/2018. The learning council submitted that in view of the notification dated 14/9/2017 published by the government of Assam, whereby an employee who dies in harness would be entitled to get the family pension of the last drawn wages, na?
Yeah.
Of the last drawn wages. Family pension would be whereby employee who dies in harness comma the legal heirs would be entitled to the salary, na?
Family pension equal to 100% of the last job.
Family pension equal to 100% of the last drawn wages of the deceased till the date of his superannuation, comma. The learned tribunal ought not to have awarded a double benefit to the claimants in as much as they would be, if they are availing the benefits under the notification dated 14/9/2017. In that regard, the learned counsel referred to the judgment of the Supreme Court in the case of Reliance General Insurance Co. Limited versus Shashi Sharma and others reported in 2016 9 SCC 627, as well as a recent order, an order dated 5/2/2024 of the Supreme Court in the case of Krishna and others versus Tekchand and others. wherein the Supreme Court had categorically observed that an employee cannot be uh, that there cannot be double benefit bestowed upon the claimants. The order of the Supreme Court in the case of Krishna and others is kept on record and marked with the letter X. Taking into account the above, the instant appeal is admitted, call for the record, steps be taken. So as the respondent numbers 1 to 4 are duly represented, extra copy of the memo of appeal is served upon them during the course of the day. This is appeal for hearing immediately upon receipt of the reports. I don't give up. It is an application filed, heard Mr. So-and-so, the learned counsel appearing on behalf of the applicant and applicant insurance company, and Mr. So-and-so appearing on behalf of the claimants. It is an application filed under Order 41-5 of the Code of Civil Procedure 1908 for stay of the judgment and award dated 6/3/2024 passed by the learned member Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati in MEC case number 655/2019. Taking into account the reasons for which the accompanying appeal has been admitted, this court is of the opinion that the impugned judgment and award passed in dated 6/3/2024 passed in MAC case number by the learned member MAC Motor Accidents Claims Tribunal number 3, Kamrup Metro at Guwahati in MAC case number so-and-so is required to be stayed subject to the deposit of an amount of rupees 44,120,80, 2,44,000 plus 33,000, 2,77,000. Na? Deposit of rupees 2,77,000 before the registry of this court within 6 weeks. Accordingly, so-and-so states subject to deposit of so-and-so within 6 weeks. So the claimant to be at liberty to file appropriate application for release of the same amount and shall release. I dismiss. Much.
14.
Yes, Mr.
In this particular case, also, he was a contractual government employee, died on 27/2020. And secondly, also, the accident occurred on 21/6/2000, 27/2/2020. FIR has been filed after 4 months, that is on 21/6/2020. As per GD entry, the accident occurred unknown vehicle. 2 GD entry was made on accident occurred unknown vehicle at night 12:30. Thereafter, the FIR has been filed after 4 months, including another vehicle, and claim has been filed against that. And that is on record. We have taken this pen in the WS. We have taken this pen in the WS also, and the DD entry also proved that unknown vehicle caused the accident at the initial GD entry. Immediately after the accident,
How did they know that this was the vehicle?
no information. Only stated that the vehicle has caused the accident.
The court must have taken into account that must be the issue number 1.
The court has taken on the basis of charge sheet by the police.
Charge has given that
Charge sheet,
right
yeah,
out of the
Yeah, that also
account
there is
of
nothing.
this vehicle. Dumper. Yes. In the 2 GT entries and also submitted delay in lodging the HR cannot be a ground to doubt the claimant's case and the effect of the following cases of the Supreme Court in Salla Verma versus. Careful stepping on the document that has been received. They revealed that the charge sheet was filed against cookie number 2, the lesser Roy in the driver of the vehicle. Found that the dumper was found. So the person was traveling by motorcycle.
Motorcycle. And according to the Lordship affair, vehicle hit him on the backside.
Huh?
Dumper hit him from the backside. It was hit from the backside. Injury is regarding head injury in the front side.
But what do you do with the police report? Did you make any investigation, submit any evidence?
So it's not examined, only charge sheet has been put. We have examined DW. We have also cross-examined the claimant, and they have examined on eyewitness also. We also cross-examined the eyewitness, whether police has recorded your statement, he said nothing. Accident occurred at 12:30 at night, no one present. And one pain has got the information that he sustained injuries, he informed the police.
Who informed the police?
One train has come from a marriage party. He saw a person lying in the road. He informed the police regarding the accident at the family.
So the accident happened. Person died. But the vehicle has not been identified. But the police, what does your investigation say?
Restriction received after 4 months FIR has been filed, and on the basis of the affair, police has filed charges against the number. And similar cases, Supreme Court has said in the judgment that when unknown vehicle caused the accident, direction was given to the Superintendent of Police to make investigation, make a special field in case of these type of cases. When after 4 months FIR has been filed, stating that one vehicle was involved, and how they have traced the vehicle.
So did you take that steps out there before the tribunal?
So we have cross-examined the claimant. So the entry has been executed by the claimant itself. We have cross-examined that their vehicle was not involved with the accident.
You have examined whom?
We have examined, claimant has examined that he is not the eyewitness. He has executed a GD entry. We have said, we have cross-examined that as the GD entry, the unknown vehicle caused the accident. Now you have filed the FIR after 4 months, including another dumper. How you have traced out the dumper, you have not.
So what does the owner say?
Owner has not confessed it. Owner has not confessed it.
Owner did not contest.
Also, that is going on. That is going on everywhere. Also, owner generally do not pick up the implant vehicle.
Now what has happened to that charge sheet case?
Our seat case, I have, at least I cannot get an information, so I can connect. And besides this, he was a government employee. He died on 2020.
You are the contractual employee.
Contractor employee.
You won't get that. It is not the issue. No, the question is admitting the appeal, but the question is, should I give a state 50% or 100%?
50% deposit. We deposit 50%, and I will collect the necessary information.
Now, if it is a case of fraud, then what happens?
Not to release at least people. Not to release.
No, no. I don't want to make the High Court rich with interest. Release will be given. Only thing is, that is the only worry.
On bond, they can pay it.
Huh?
On bond, they can pay it.
Bond has no value. You also know, I also know. Nobody is bonded with the bond. You can't do anything wrong. These bonds used to be there during the British time when the people were good. Isn't it? Tell me, what can you do with a bond? I've seen in the civil litigation. Bond has no value. But he said that he has given a bond, so he will be bound. Some people think, but what can you do with a bond? You can't put it in the bank area also when the back is. No. What is the bond? No. তুই আমার নর্মাল অর্ডার দিবি অ্যাডমিট করে দিব call for a record sequence complaint. It will stay 50%. Release by the
Response number 124 APR.
release by do one thing. We do one thing. Let this 50% be not deposited before the registry. Let it be deposited before the trial. And if you see paragraph number 16, let us pass that order that the learned tribunal, while disbursing, shall duly take note of paragraph 16. Let us see what happens. In fact, yesterday there is a judgment of the Supreme Court wherein it categorically says that you are to directly only give it to the bank. Not only then, if it is also to be given to the bank or the fixed deposit also, it is to be deposited directed to the so-and-so bank. And the bank will then make the fixed deposit and keep it. So it should be there in the award itself. Have you seen that?
I've seen.
It will if you need, shall deposit the 50% of the said amount along with the accrued interest before the tribunal within 6 weeks from today. This is the ground of stay. Upon deposit of the said amount, the learned tribunal shall disburse the said amount to the claimants. In terms with paragraph 16, of the impugned judgment and award dated 11/1/2024, passed in MAC case number switch.
124 has appeared. 124 has appeared, name is which only the causes.
So the I disposed of. Appeal has not been admitted. Their loans have been, how it is shown?
There is a petition for confirmation of data, they have appeared.
So you take steps, no problem.
On respondent number 3 and 4. Respondent number, other respondent.
Take steps. Did you go on, you deposit the 50% like that.
Except 124. 124 and personally short, they have appeared. 124, they have already appeared. I would give you extra for the them. And 6.
Nobody has appeared today. Their names have been shown. So and so, the appeal filed on the so and so, so and so. So the appeal is admitted. With Mr. So and so. It is seen that the claimants are duly represented by a set of counsels. Considering the above, no extra, considering the above, there is no requirement of any formal notice. The appellant shall serve extra copies of the memo of appeal upon the counsel appearing on behalf of the claimants. As regards the respondent number so and so and so and so, steps be taken by way of registered as well as usual. All for the records. It's the matter of the completion of service as well as the receipt of the records. Because we actually need your help to bring this matter to a logical conclusion. I only wanted these two documents to search the authenticity of these two documents, whether it is original, I mean, if it is original or it's not fake, then obviously this court can pass appropriate orders.
Yes. Monday, Monday.
Madam, why do we find this service book is date, the year is different, I mean, so put it in a different ink. The ink out there for the year seems to be different. It seems to be overwritten or something out there. You see it in a service book?
The year is not. Fine, 27/8 আছে, that's the year. Yeah, the next page from 27/8 আছে. Year 27/6. এটা তো শুধু
So this service book was prepared by the subdivisional judicial magistrate Dhemaji. So if that was prepared by the subdivision judicial magistrate Dhemaji, how she has put it in the particular service book, the date of birth? Because yesterday the chief judicial magistrate says that they don't have any records. It was done in the by the district judge in Lakhimpur. But how is it possible?
out.
Now, he was appointed by the district and section judge Lakhimpur, order number so and so, dated number so and so. Okay. Is temporary. Lower division clerk so and so. It was being signed by the subdivisional judicial magistrate in 27/8/2000, whatever may be, 1987. So in 1987, when the service book was prepared, how did the date of birth was put like this?
Entered as 5/3.
Somebody has to put it like this. So, Mr. Torunsuke, can we find and get the information by Monday? Monday. Yes. Adjournment, the learned standing council of the Guwahati High Court, pursuant to the order passed by this court on P3/2025, has placed before this court the scanned copy of the service records, service book of the petitioner. First, yesterday, when the matter was taken up, the chief judicial magistrate, Dhemaji, was present through the video conferencing mode, who submitted that the appointment of the petitioner was made by the then undivided by the district and session judge, not Lakhimpur, as at that point of time, the courts at at that point of time, the uh, court at Dhemaji was a subdivisional court. So this court have also perused the service book, the scan copy of the service book, which was produced. The same is kept on record and marked with the letter X. From a perusal of the said service book, it is seen that the service book was prepared as far back as on 27/8/1986. 86, no? 86. And in the said service book, the date of birth was mentioned as 5/3/1965. However, it is not known. However, as per the Chief Judicial Magistrate, Dhemaji, it is not known on what basis the said date of birth was entered. Be that as it may, the learned counsel appearing on behalf of the petitioner have placed before the court the admit card issued to the petitioner by the Board of Secondary Education Assam, as well as the high school living certificate issued by the Board of Secondary Education Assam, enclosed as Annexure 1 and 2 to the writ petition. From a perusal of the said two enclosed annexures, it is apparent that the date of birth of the petitioner is 16 years, 8 months, 0 days as on 1st of March 1983. Taking into account this court, in order to verify the authenticity of Annexure 1 and 2, had requested Mr. T.C. Sutia, the learned standing counsel of
Astral Seva.
Seba, erstwhile Seba,
Now it's changed.
now
Now Assam State School Education. That's it.
Assam State School Education Board, to inquire and to verify as to requested Mr. to verify as to whether the Annexure 1 and 2 to the writ petition are authentic copies, are authentic copies of the admit card as well as the pass certificate issued to the petitioner. Mr. A. Hassan, the learned counsel appearing on behalf of the petitioner shall serve a copy of the writ petition to Mr. T.C. Sutia, the learned standing counsel, so that he can take appropriate steps in that regard. Because taking into account that the matter is urgent in nature, this court fixes this matter on 24th of March 2025. Because Mr. T.C. Sutia shall place before this court on the next day as to whether Annexure 1 and 2 to the writ petition, which is the admit card as well as the pass certificate issued by SEBA, are authentic and genuine copies. This the matter again on 24/3/2025 at 2 p.m. The registry shall show the name of Mr. T.C. Sutia, the learned counsel, appearing on behalf of SEBA.
Or I have some grave difficulty with my colleagues. I've tried to make arrangements for the hearing, 2 matters in the hearing.
Tomorrow.
If I may, please be accommodated. Next week, any day, madam. Please be accommodated.
Tomorrow, anyway, it's okay. But this matter is urgent.
Yes, I'll be there.
10:50 to 50 PM.
I have filed the affidavit that they have lost because of the date of filing. Short time.
Step my client, nothing that is, but due to her years, but come very short time. This 21 letter is safe, everything.
No, it's okay. Let them go ahead and construct. But they, if in the circumstance anything happens, the suit is decreed in your favor. There is no requirement of any further decree from the court. He will hand over the possession. This is the undertaking. We'll take it. Secondly, that during the pendency of the suit, he shall not create any third-party rights over the suit. I think your protection, you are safe because he's admittedly in possession.
But this another post order, I tell me to inform her, but if you had details.
Understood, but you see that at the end of the day, Mr. Counsel, you see, when an injunction is granted, if you see the judgment of the Ronald's judgment, normally when an injunction is given, one has to have competing, there has to be a balance. What is the balance you can maintain? The balance you can maintain it in the circumstance tomorrow. Why you want that they should not construct? Tell me, give me a good reason. Give me a good reason.
I request you that.
No, forget about other things. Let us go on the merit. Give me a good reason why you don't want her to construct, him to construct. Tell me.
Case is pending with the trial court.
Understood. But tell me why you do not want him to construct.
Until now, the case is said that it is uncertain in this favor it will be passed. It may be passed in this favor or in this favor.
Fantastic. Then
In favor for like that court. Then I shall.
very good. Now tell me why in the meantime you do not want him to construct. Give me a clue, idea why.
Trial court has given intention order.
That is why I'm here, sitting out here.
Rejected. Subsequently, we have had civil division petition before this honorable court. Honorable court also asked to maintain a status. This is on record. Subsequently, they approved the Supreme Court also turned down. And now.
No, Supreme Court granted them a leave. And on the basis of which they sought for the leave. Now, therefore, I'm asking you, why you do not want them to construct? You do one thing. You deposit an amount of rupees 25 lakhs by way of a bank guarantee before the trial court, which will be subject to the outcome of the suit. In the circumstance you lose the suit, you pay him this amount. We put that condition in. No, I direct it. I give that order to the effect that you pay the 25 lakhs as by way of a bank guarantee before the trial court, submit it, and in the circumstance that will be subject. Tomorrow you win, no problem. No, nothing, no short time. Absolutely no.
One small short time.
Widow lady, it will be better for her. She gets a constructed house. She'll get a constructed house.
Getting amount.
No, she'll get a constructed house without a decree. The main reason why no construction is given, because if you construct out there, there are two things. The first thing, the suit property, the constructed property is not there in the original suit. So what happens when you get a decree, you can get a decree over the land only, not over the house. But he gives an undertaking before this court, which will be binding. That in the circumstance he loses the case, he will hand over the building to you without any decree, for the decree being sought for. One. Secondly, you may say that, okay, tomorrow if he constructs out there, he may create third-party rights, which may need, just for example, a four-story building is being given, he gives it on rent to somebody else. for which the problem will be later on that you may have to seek for eviction of those persons also. Although in terms with order 21, you need not, if he's a tenant, but then also there will be unnecessary litigation. So he also gives an undertaking that he shall not create any third-party rights in respect to the constructed premises. So you are safe in that regard. This is for me to explain. Thereafter, my duty is to pass an order. Did you get the order which I passed in Justice Mr. Samnur Ali's case?
That I couldn't get.
Some order था decent one. Really decent. One hand, Mr. Samnur Ali was there, on the other hand. Now, heard Mr. P.K. Roy, the learned senior counsel, assisted by so-and-so. And Mr. so appears on behalf of the respondent. Numbers 1 and 2. What number 3 and 4? Who are all these people?
Well, they are the vendors, not of the petitioners and the respondents. They are the vendors.
Yeah, actually, who are the plaintiffs?
Well,
Plaintiffs are who?
plaintiffs are of 1 and 2.
Appears on behalf of respondent number 1. The instant petition has been filed by the petitioner, challenging the order dated 21/2023 passed in petition number 680/2025 arising out of title suit number 224/2021, whereby the learned trial court rejected the said petition. For deciding the legality and validity of the said order dated 21/2023. This court finds it relevant to take note of the facts which led to the filing of the said application. The respondent number 1 and 2 had filed a suit against the petitioners herein as well as their vendors. Taking declaration of their right, title, and interest within the area of the first scheduled land of their second scheduled land, and for confirmation of possession thereof, except possession of third scheduled land in view of dispossession. Similarly, for declaration that the petitioners herein, who are the principal defendant numbers 1 and 2, were illegal encroachers and liable to be evicted, thereby dismantling any construction that may have been found therein. For declaration that in the facts and circumstances of the case, the principal defendant or anyone claiming under them are not entitled to make any construction in the first scheduled land till proper survey, measurement, and separation of the respective land of all the parties involved, including the plaintiffs. For recovery of physical possession of the third scheduled land from the illegal possession of the defendant numbers 1 and 2, or any further area of the second scheduled land of the plaintiff, if so found, and if necessary by holding proper survey, measurement, and demarcation, and separation of the second scheduled land of the plaintiff with the area of the first scheduled land, and removing all structures, impediments that may be found. For mandatory injunction, for declaration and cancellation of any document created by the principal defendants concerning any part of the first scheduled land adversely affecting the second and the third scheduled land, for survey and for permanent injunction. Along with the said suit, now, it is pertinent to mention that the deeds of sale which were executed by the defendant number 3, 4, and 5 in favor of the defendant number 1 and 2 were also challenged and appropriate declarations were sought for. Along with the said suit, an injunction application was filed seeking what injunction did you ask? Seeking injunction, temporary injunction restraining the OP of the principal defendant. Where is the page? Where is page 16? Huh, you have not enclosed this. Can't help it. Mr. Roy,
But
can't help it.
the trial court order is there.
Sorry. This is the matter. File the affidavit, you have not filed it properly, I can't help.
But the temporary order. is
How
not-
much time you require? About to pass an order, not 10th of April, this is the matter on 2nd of April. The request, an affidavit has been filed by the counsel appearing on behalf of the, for the petitioners in pursuance to the order passed by this court on so and so, according to the counsel appearing on behalf of the respondents seeks some accommodation to list this matter again on 2nd of April 2002.
Supplementary item 49. Item 49.
Really? So first time being called.
50,
Timing.
Hearing under.
Timing. Ako 3,000. 3,000. Yes, Mr. Goswami, you'll have it on 8th of April. Because if I take it, I'll dismiss it. If I take up the matter, I'll dismiss it. The request of the council for the appellant matter to be listed again on 7th of April. That's all.
That's item 17. So which notice of 13/6/25, madam. That is upon number 326, madam.
Huh?
Not AD card, not conserved receipt.
No, no, Mr. Counsel, why do you need to perform defense number 326?
They are the defendant, my lord, but they are not contesting.
So, no, why you have make them perform a respondents?
But they are the defendant. So
You are also a defendant.
Yes.
So they are not contesting their suit. So they are not fighting against you. So why don't we strike off their names? Well, then the service is complete.
Right.
With the service, LCR has been received.
Yes.
The learned counsel appearing on behalf of the appellant submits that as the performer respondent number 326 did not contest in the suit and they have no adversarial interest against the appellant, the names of the performer respondent number 326 be struck off. First, taking into account the said submission, the name of the performer respondent number 326 is struck off. The counsel appearing on behalf of the appellant is directed to file a fresh memo of parties before the registry of this court. And the registry of this court shall, on the basis thereof, shall make necessary correction in the course title as also update in the CIS. Further to that, taking into account that the LCR has been received, list the matter for hearing on 6th of May 2025. 18. Service complete? Service complete? Madam, service complete or not? Yes.
What's it, the
LCR.
appellant expired, okay,
See, you don't know that, madam?
19th September 2021.
Who is your senior?
Chaudhary. D. Chaudhary, Dilip Chaudhary.
Mr. So-and-so appearing on behalf of the respondent submits that the appellant had expired, sole appellant had expired on
19th September 2021.
19th September 2021. He therefore submits that the instant appeal has abated. The counsel appearing on behalf of the appellant, Ms. So-and-so appearing on behalf of the appellant submits that she obtain instructions in that regard. To list this matter again on 4th of April 2025. So it is observed that if the appellant had expired and no steps is taken in the meantime, the instant appeal shall automatically abate.
19.
Your Lordship, Your Lordship, while trying to contact the client, we come to know that the appellant has expired. On the last occasion, my lord had instructed to take upon steps on the newly impleaded respondents, as in the substituted respondents.
When did the appellant expire?
That date we are not able to.
Don't say then.
My lord,
What is the case about?
my lord, the tenant and
Landlord tenant. Oh, yeah, guide. So what does he do? He doesn't require the property. We dismiss it.
landlord
We'll dismiss it.
will
Why
file the appropriate
what else? Why are you fighting for a dead person? He doesn't require the property.
petition.
And when did he die?
My lord, the exact date, as in date, I'm not aware.
Then
We'll file an appropriate.
who is paying for the respondent? None. It's such an old matter. It cannot be. Your senior is D. Chakraborty.
No, my lord. We should.
D. D. Sharma. Yeah, there is some D. Sharma appearing. D. Sharma. Oh, nothing. Landlord tenant. How many years?
This.
You have been here from 2015 onwards in the High Court. I think it's high time dismissed. Enough. How many times you have to be there? Court has held you to be a defaulter. Defaulter.
No, my lord, they have come up with certain grounds that we have sublet the area as such. So, my lord, that will be contested.
Huh?
File an appropriate petition. One short date.
Bona fide requirement. Subletting.
Yeah, contested.
Defaulter. Normally, we have only two circumstances. Now, in three circumstances, it is a fit case for dismissal. When did the appellant expire?
And
The counsel appearing on behalf of the appellant submits that the appellant had expired, the petitioner had submits that the petitioner had expired. Full stop. He, however, submits that she doesn't know when the petitioner had expired. Consequently, list the matter after 2 weeks. List the matter again on 4th of April 2025. It is observed that if no steps are taken in between within that time for filing appropriate application, this court shall pass appropriate orders discontinuing the interim order which was passed through.
Item 20.
If I have expression to refer to aspect by language,
And 11,
is the other aspect.
Then- you are to appear for 9. Who is 10 and 11?
10 has already been, you are not looking at, the response number 10 is served, you are not. Regarding 11, you are not, as part of office note dated 6/3/25, you are not, the ID card is not returning.
I'm not on that. Who is 11?
No,
Who is the respond number 11?
first the defendant, he filed the return, thereafter he did not contest the case.
Okay. And he is the defendant. And he is the performer,
Thereafter he
contested. But he doesn't, and did he contest against him? You strike off the name of 10 and 11.
Conducting counsel, Mr. P.K. Garuda actually is out.
Ah?
The conducting counsel of this case is out of station, Your Honor.
So what do I do? No, you are not the counsel here in this matter.
I am hearing on behalf of Mr. P.K. Garud.
Oh, you are not a person who signed the wakalatnama. Oh, fantastic. You are one of the conduct. Fantastic. Come up with that type of excuse. Mr. G. Bharadwaj appearing on submits that he has instructions to appear on behalf of the respondent number 9. And he has filed wakalatnama.
I'll try to.
And he will be filing the power within a day or so. As regards the respondent number 10, respondent number 10 and 11 being performer respondents, and their interest being not adversarial to the interest of the appellant, their names are struck off. The counsel for the appellant shall within 3 days file a fresh memo of parties before the registry of this court, and on the basis of which the registry shall make necessary correction in the cause title and also update the same in the CIS. Taking into account the above, the service is complete and the LCR having been received, list the matter for hearing on 8th of May 2025. Liberty given to the parties to mention the matter for upgrading.
But you are.
Yes, faculty. What is this matter going on for such a long time? 2016 CRP is for what purpose? What are you challenging?
Yes, Mr. Lordship. Lordship, in this matter, we were to take steps upon the respondent.
Forget about steps, I'm not on that.
If
If I dismiss your petition, forget about steps, you'll be spending less money. Tell me, what are you challenging? We are not concerned with our role. What is it challenging? Let us see. Unnecessary matters should not remain. 7/12/2015. See that order. Order 21, Rule 27, read with section in there filed by the appellant praying to allowing the heir to adduce additional evidence and to call for CR. Objected to this petition stating the charge sheet evidence submitted against the PW1 has no relevance in this appeal, hence it's not required to be brought on record. Who filed this appeal? Application. What is this matter about?
Matter is related to ejectment of.
And why there is a connected MAC appeal? McCap? লগত কি এটা লাগি আছে? কিবা লাগি আছে নেকি? নাই না? Now, no relevance. Learning counsel for the parties and so and so. What is found out from example in supply is that if the appellate court can pronounce the effective on the basis of the provisions of the act cannot be applied without meaning new evidence should be have a dynamic and important bearing in confidence that and no necessary to allow the appellant to use additional evidence to appeal and call for the report of additional evidence. We will reject it. So, you are paying for?
Who's sick?
Who are you? Plaintiff?
I'm the son of the. I'm son of the client.
You are the son of the plaintiff. So you are representing the plaintiff. So they have filed an appeal.
They filed appeal.
They wanted to bring on record order means certain documents, additional evidence.
Lordship,
Yes, she wanted to file an additional evidence in the appellate stage.
They want. I have filed an agreement in the suit. They are telling that this is a force law. And initially they have also filed a petition for evidence, which was rejected. Again, they have preferred a CRP, which was also dismissed. Page number 45.
Then Yes.
What you're putting, I'm not intending to invoke the power in the suit.
To send exhibit 1 to forensic laboratory. This is different. What he wants, what does he want here? Let us see the application on the order 41 rule 27.
That is a basic.
From the charge sheet it's so and so. May call for the records of LCR from the records. The charge sheet number so and so, Parperia is the vital and primary facie shows that the document of the lease was forged by the so and so, and unless the said charge sheet is not allowed to be brought on record by adducing additional evidence by the appellant, then in every case the possibility. So he wants to bring the additional demand, the charge sheet. And okay. We do one thing. We interfere with this order. We interfere with this order on the ground. However, without deciding on anything, but in view of the Ibrahimuddin, that this application should be decided along with the hearing of the suit appeal. If the court find it at the hearing of the this was taken premature.
They are fighting the various.
The counsel, at the end of the day, what do you want? You want your appeal to be dismissed, no? The appeal will be dismissed. But if you see Ibrahimuddin's judgment, categorically say that the stage on which Order 41 Rule 27 is to be taken is at the time of hearing and has to find out as to whether at the time of writing the judgment it is required or not. Okay. Now what has happened? The first appellate court had decided it prior to that. So without expressing anything on merit, on the ground of the stage, let it be done. This application I restore it, and the court will consider at the time of delivering the judgment. You may dismiss it. I'm not saying that whether it is required or not. We dismiss it on that ground. But by this, your appeal starts. His appeal gets dismissed someday, isn't it? You can't say anything because I'm allowing your petition. Heard?
And he not on behalf of the.
No behalf because you have done the great job of appearing and getting a matter decided in your favor. Tell me. So and learned counsel appearing on behalf of the appellate, petitioner, and Mr. So and so appearing on behalf of the respondent number 2 to 6. The instant petition the present petition, the instant petition under Article 57 of the Constitution is filed challenging the order dated 7/12/2015 by which the learned First Appellate Court had, prior to the hearing the appeal on merits, disposed of the application under Order 41, Rule 27 of the Code. This court at this stage finds it relevant. Now, for the purpose of adjudication of the instant proceedings, this court finds it relevant to take note of the judgment of the Supreme Court in the case of Ibrahimuddin, Union of India versus Ibrahimuddin, reported in 2012, 8 SEC page 148. And more particularly, paragraph number 49 to 54, wherein the Supreme Court categorically observed the stage of consideration of an application under Order 41 Rule 27. It was categorically observed by the Supreme Court in paragraph number 49 that an application under Order 41 Rule 27 of the court is to be considered at the time of hearing of the appeal on merits, so as to find out whether the document and or the evidence sought to be adduced have any relevance bearing on the issues involved. First, taking into account the settled procedural of law, this court, without making any observations on the aspect as to whether the said additional evidence is required to be taken by the appellate court or not, interferes with the order dated 7/12/2015, impugned in the instant proceedings only on the ground that the said application under Order 21 Rule 27 was decided for this, was taken up for disposal prior to hearing the suit appeal on merits. This court further restores the application filed by the petition appellant, petitioner herein who is the appellant, under Order 41 Rule 27, read with Section 151 of the Code, to the file of the learned first appellate court. It is further observed that the learned first appellate court, while upon hearing, at the time of hearing of the appeal on merits, shall, taking into consideration the observation made by the Supreme Court in paragraph number 49 of the judgment in the case of Ibrahimuddin, consider the said application under order for files under Order 41 Rule 27 by the appellant and pass and accordingly the instant petition stands allowed. It is made clear that the observations herein, it is made clear that the observations made in the instant order, as well as the setting aside of the order dated 7/12/2015 by the learned trial court, shall not prejudice, by the learned first appellate court, shall not prejudice the first appellate court while deciding the appeal or the application under Order 41 Rule 27. As both the parties are duly represented, they are directed to appear before the learned trial court, first appellate court, that is the court of the learned civil judge, senior division, civil judge, senior division at Tinsukia on 3rd of April 2025 for further proceedings of the appeal being entitled Appeal number 11 of 2010. Okay? Win-win for both of you. Junior division. It can't be junior division. How can a junior division be an appellate court? Mr. Khabra. Yeah, Mr. Khabra. How can you think you practice in the civil court, you don't know? Have you ever seen the junior division being an appellate court? But you just find out one thing before this order is signed as to whether it is whether the Tinsukia has one or two senior division or not. Just find out that. Okay. What is this? AP matter here. What is wrong? 22. Who is appeals? Non-appeals. Registry shall make due inquiry whether the pendency of the institution is known to the councils engaged. What has happened? What is this matter about? Once these matters are dismissed, these people will wake up. Why is this matter brought here? None appears on behalf of the party in registry to comply with the order. It results from the previous order that the was previously heard by the citizens. High Court advocate, any advocate from High Court? No. None appears on behalf of the parties on call. For the ends of justice, the matter stands adjourned to be listed again on 16th of May 2025. The registry is directed to bring to the notice of the petitioner as well as the respondents about the pendency of the instant proceedings and that the next date is fixed on 16/5/2025. In addition to that, this court have also taken note of that on behalf of the petitioners, wakalatnama has been filed. Also, the registry shall also intimate the advocates who has filed the wakalatnama about the pendency of the instant proceedings and then that the matter would be taken up on 16/5/2025. So it is observed that in the circumstance, none appears after due intimation, the instant petition shall be dismissed for non-prosecution.
23.
Excuse me. There is some lapse on my part, but I'm not taking step, but one more chance may be given.
What is the matter about?
Matter is, my lord, I am extremely sorry, my lord. Today I have also missed the brief.
Let me
Yes,
look into it.
It has come to my notice after coming to.
Don't require, let me look into it. If I can dismiss it, you don't need to take steps.
I cannot say anything, my lord, because I have not gone through the petition.
Not necessary,
Brief is not with me.
not necessary. Let me just try to find out where is the impugned order.
Lord, Lordship may take up the matter on Friday.
No? Why I am not going to take up of the matter? Because in 2020, there
Right.
have been petitioner praised for time to take steps from 2017, 19,
My lord,
20, 2020. We have
I-
not
I-
taken.
my lord, I do agree, my lord.
because I have nothing to say.
What is the order passed?
I'm admitting my lord, my lapse.
If I think you have a case, then in that case,
I'm sorry.
why you are filing under 227? It's a decree. You have to file an appeal.
I thought, my lord, possibly, my lord, I'm not gone through, I have forgotten everything. Possibly, my lord, there was some fraud being done.
Fraud, whatever fraud, it is not the fraud of the court.
That was the consideration.
Mr. A.K. Purkasto, the learned counsel appearing on behalf of the petition. The present proceedings is the proceedings under Article 227 of the Constitution challenging the judgment and decree dated 23/9/2016, passed in title suit number 11/05, whereby the suit filed by the plaintiffs was decreed. So taking into account that the suit had been decreed, the remedy lies under the Code of Civil Procedure to file an appeal thereagainst. However, in the instant case, the petitioner herein have invoked the supervisory jurisdiction of the court under Article 227 of the Constitution. In that view of the matter, well, it is well settled that the jurisdiction under Article 227 of the Constitution of India cannot be exercised or cannot is barred when the Code of Civil Procedure specifically mandates a remedy. So consequently, this court dismisses the instant application on the ground of maintainability. Interim order stands vacated.
And my lord, an observation then, my lord, so that I can approve the.
Now,
that
because
period-
of the fact that you have not, you know what to do. Why should I say?
That period maybe, my lord, the period when you mean, my lord, in the High Court maybe.
You have not taken steps from
That's
2017.
right, I admit my lord.
Mr. Purkar, sir, you,
Only
either it is the fault of the council or it's the fault of the petitioner. Either of it. Don't tell me, because the moment you ask that, I will say that you have not taken steps and as such not bona fide litigating before this court. And accordingly, you don't get the benefit on the 14th. But when I pass the order that this I have not, you know what to do.
Is your lordship? Your lordship, as per office record dated 17 March 2025, acknowledgement card of respondent number 2 has not been received yet. However, notice has been issued already to both the respondents.
What is the ground of objection?
Your lordship, in this case, this himself was driving the vehicle, and due to his rash and negligence and mishandling of the vehicle, he died on spot. And therefore, the national insurance company is not liable to
Hmm?
pay the compensation.
Now, what is your
Also under
ground of
section,
objection? Ground of objection is what?
as per section 163A, which provides that the claimant is not required to plead or establish that the injury sustained or death caused was due to any wrongful act or neglect or default of the owner of the vehicle or of any other person, and the said section also does not provide an exception.
Understood, but what is your ground of objection? Is it on quantum or what?
Your Lordship, we are not responsible to pay the we are not responsible to pay the compensation.
So it is, you are not responsible. Why?
Because Your Lordship, the deceased himself was driving the car. The deceased, the one who died, he himself was driving the car, and due to his rash and negligent driving, he was died on spot.
So it is on
And-
contributory negligence.
Yes, no, Your Lordship. Your Lordship, respondent number 2, who is the owner of the vehicle, but the deceased, he is not the main insured person under our policy.
Huh?
He is not the main insured person.
No, respondent number 2 is the owner of the vehicle. Your case is that the deceased, he had driven rash and negligently, so you are not liable to pay. That's your case. So why do we need the owner?
He's a necessary party. He's a necessary party.
That I know. But why do you need him here when you are challenging only the quantum?
The father of the deceased. He's also the father of the deceased.
Very well. Father of the deceased. And who is the respondent number 2 1?
The
Respondent
mother,
number 1?
the mother of the deceased.
Mother of the year. So she is already there.
Okay, anything, kindly list the matter
There.
over there.
Now tell me, if it is your case of contributory negligence, what is your proof you have adduced?
Not to pay the compensation at all.
Understood, you don't pay, but what is your proof?
Lordship,
You say that it is not your fault, the fault is them. But the fact remains that there is a vehicle which is being driven, which is insured by your company. If your vehicle is insured by your company, you are necessarily required to indemnify, isn't it? If anything happens in respect to the vehicle, you are necessarily required to indemnify. You are saying that as he has driven in a rash and negligent manner, that person, the deceased, so therefore you are not going to pay. Isn't that your question? Then why do you pay for all other cases where it is being driven for the rash and negligent driving?
Lordship, in this case, have on under the ground that under section 163A of MT Act, we have just read it that we are not liable to pay the compensation. Also under section 147.
Record, I think. This type of matter should be immediately disposed of by dismissing.
Matter for hearing.
Huh?
I think it's a matter for hearing.
I'm hearing you. What else do you need? You don't require more hearing than that.
The engaged counsel, I'm very new.
You are not the person.
The engaged counsel, I'm
But let me then dismiss. Let me then dismiss for default.
I'm very new, 4 months.
Negligently drove the vehicle without any treatment. Why? You did not give evidence. Then you are there. You didn't give any evidence. Then without that evidence, how can you say that it was his fault? You are appearing for the mother, not the father. Why? They don't like each other. There might be some reason. Maybe they may have been divorced.
Because of that accident, perhaps the son died. So there may, because of that accident, perhaps the son died because of that strained relationship is there.
They are having strained relations.
Maybe not, I don't know.
Well, at the end of the day, the mother would be getting the money, which the father doesn't want.
There
I
is
think
a such
to that
no
effect.
written statement in the part of the father.
Huh?
The party number 3 only, that means the insurance company filed the written statement. This claim is, the application was made under section 163 of the vehicle. That issue has been taken into consideration by the tribunal. Issue number 1. Where the alleged accident occurred due to the use of the offending vehicle. It has been elaborately mentioned by the.
Where issue number 1?
Issue number 1 is page number 43. Lord. The last 3 paragraphs. Page 43. Though in written statement, opposite party number 3 stated that the vehicle was not driven properly by the disease, but opposite party number 3 there no evidence to substantiate such rash and negligent driving of the disease at the time of accident. The claimant has furnished driving license in the disease, which was valid up to certain in the case of Injunction.
No, in the insurance policy, there is always a mention that there is one judgment I forgot. The R. Goswami was there long time back. If it is driven by the owner, then the liability is limited to a certain extent. If it is third party, it's a different aspect. But if it is driven by the owner, now the son having been driven, the liability is limited to a certain extent. Isn't that, Mr. Batra? There is some judgment of the Supreme Court, I remember. Huh? Yeah. So it is limited to the. Huh? No. No, the liability is limited to what is mentioned in the insurance policy. It cannot go beyond that. So here the insurance policy was there, exhibited must have been. Where the insurance policy? Not exhibited. There's a Supreme Court judgment after this. There's a Supreme Court judgment on this. No? What does it? What is the name? Ningama. There is one with starting with R. I forgot. Something like that. I had disposed of one matter where Miss S. Roy was appearing. You have a lawyer, huh? S. Roy. So there it says that you cannot give more than what is given in the insurance policy. A third party's right is different, but here he does not become a third party. He steps into the shoes of his father. So his liability will be limited to what is stated out there. But without the insurance policy, how do I know? You do one thing, madam, we don't require number 2. You are liable to pay. There's no quarrel with that, but it is limited. So you bring on record the insurance policy by filing an additional affidavit. Well, that is the law. So that has to be, it may be more than 5 lakhs or 6 lakhs maybe. You may not get 9 lakhs or whatever it may be. But whatever it is, you can get only on that amount. Limited to that amount. You can't go beyond that. This court have duly taken note of the fact that the claimant is represented. And the only issue raised is as to whether the claimant would be entitled to an amount more than what is prescribed in the insurance policy, taking into account that the son of the respondent, that the deceased was the son of the owner of the vehicle. This matter again on 24th of April 2025. At the top of the list. Also, the counsel appearing on behalf of the National Appellant Insurance Company shall bring on record by filing an additional affidavit by 21st of April 2024, the insurance policy in question. Also, the matter be shown as part of
25.
What is this?
Tenancy against the order passed the appeal. And that's why it doesn't enter the appeal, right? They can speak.
Appeal dismissed.
Appeal.
Order 9 Rule 13.
Right.
What is wrong with that order?
And basically the ground shown that I have not challenged the judgment ending. But I have filed the application for setting an expiry degree that was dismissed. Accordingly, I have challenged the order whereby my application has been dismissed.
Right.
The appeal, my lord, the ground is so for dismissal of the appeal that I have not challenged the judgment ending.
What? What is wrong with this? Show me that.
My lord, page, my lord, 37, paragraph 5. Some wrong was also on our part for drafting the memo of it.
No. You are challenging what?
Challenging that order 5, order,
Ex parte order. What
Yes,
is this 25-7?
yes,
What is the 25-7 order?
that page, my lord. Expert is judgment ending.
Huh?
I have challenged.
Where is your application?
Application is at page 23 Annex 13. It was proceeded expert, subsequently
judgment decree has been passed. for
Ex parte
sitting
order dated 25/7/2023.
Page 7.
This is the order we are
This is
challenging,
The order whereby the ex parte judgment is passed.
25/7/2012.
Fine.
We have challenged that only.
Yes, I have challenged, by filing in this case,
Huh?
under order 930. For
So you
sitting-
challenged that only.
Yes, ma'am.
Then what happened?
Then my lord, that was dismissed, my lord. That is the page, my lord.
The application is not supported by an affidavit or affidavit is there. Then that
My
was
lord, then, my lord,
dismissed.
that petition has been dismissed by the order dated 28/2013. Page, my lord, 30. Against that, I prepared it.
Record has been come. What about the service?
But, respondent has not answered. I have taken stage.
Huh?
I have taken stage, my lord. On defined days. Record has also. Have taken the call.
We have not taken steps.
My lord, on my lord, 2/12/21.
Interim order, we vacated.
My lord, so far, recording same. I have taken step.
When?
These are the problem next.
You take steps by way of registered the dusty upon the respondent. Nothing, not this type of matter. Very long.
21/2019.
This can't go on like this.
19/2019. Again 2/12/2021. Again 13/6/2019. I have taken.
No, take steps by way of dusty, and if you cannot file anybody, very well. It is seen that the steps upon the respondent, sole respondent is not complete even after a passage of the instant proceedings being pending for the last 7 years. First, the counsel appearing on behalf of the petitioner herein is directed to effect service upon the respondent by way of dusty routed through the registry of the spot and file an affidavit of service on or before the next date. First, list this matter on 16th of May 2025. First, if you don't take steps next time, nothing doing. Dismiss it.
All right. Six. That report. In this case, the response number 3. The service I will take a step and just paying.
What is this CRPIO business?
CRP means lordship is, at the time of producing evidence lordship, the exhibited documents are not produced before the court. So file an application under section 137 of the Evidence Act for allowing the plaintiff to exhibit those documents by way of re-examination.
For allowing?
Allowing the plaintiff to exhibit those documents by way of re-examination. Because we have mentioned it in the evidence as exhibit, because those documents were not produced before the court. So the application was filed. It is at page number 21, lordship, the annex 3.
but that was rejected by the trial court. 27th of article, page number 28.
You want to summon official witnesses.
Separate application. Two applications were filed also on the same day. Two applications were rejected because the first application with regard to the re-examination, that was rejected in view of that. Since there is no such document on record as exhibit, the learned trial court rejected the subsequent application.
Now, did you file these documents at the time of filing of the evidence?
Yes. No, not filed also. Not filed.
Then,
Although it has been mentioned as exhibited documents.
then how are you going to prove these documents then?
Lordship, for by way of re-examination, Lordship. By way of re-examination. You just filed an application under section 137. I want to be this for the re-examination.
Where is the question of re-examination?
The
There cannot be a re-examination. You cannot re-examine something which is not there. You have to recall the witness under 151.
the plaintiff filed this.
Mr. Counsel, it was earlier the provision of order 18 rule 17A that has been removed now. 151, you have to bring in some other witness to prove these documents. You cannot go by re-examination if you have not given any the document.
This is a inadvertent error on the part of the plaintiff.
So what? Error, no error. Where is the question of re-examination?
So by way of re-examination, Lordship, he wants to place those documents on record.
Go to Supreme Court, Supreme Court. I dismiss it. Not be a re-examination, rightly dismissed.
But it has been mentioned only as a mistake on the part of the
And what is the case of evidence, the defendants?
defendant not started.
And it was stayed. And the service is not complete.
So,
Who is the defendant? Defendant number 3?
defendant number 3, Lordship, this respondent number 3 is the defendant number 3.
Huh?
Respondent number 3 is the defendant number 3.
I vacate this order. No interim order, we vacate it. By which if you can complete it, when so fresh steps have been taken from here, here the petitioner is not interested to pursue. Okay. Taking into account that the petitioner have not taken steps as regards the respondent number 3. Respondent number 3 is the defendant.
Defendant and the plaintiff.
Defendant. Because the respondent number 3, in spite of various opportunities being granted, this court is not inclined to extend the interim order passed earlier. Full stop. No, not necessary to put this. So this court duly takes note of that by an order dated 1/12/2021, this court had categorically observed that if the petitioner failed to take steps upon the respondent number 3 within the time prescribed, no further extension of time, extension of the interim order would be granted. Thereupon, steps was being taken. Thereupon, the record reveals There were various directions issued by the Lozima court to the petitioner to take steps upon the respondent number 3. However, no such steps have been taken. Consequently, this court is not inclined to extend the interim order passed by this court by this court on 24/8/2018. Accordingly, the learned court of the civil judge, junior division, Kamrup at Aminda, shall proceed with title suit number 402/2014. The registry shall duly intimate this order to the learned court below. All right.
57 and 28.
Yes, what is this?
My lord, the improved order, the lord should find at page 10 and etc.
Now, these appeals have been admitted. Why the matter has come up before this? No LCR has been received. Regard or have not been received back yet. Who is 1 and 2?
Here was not also. My lord, the 1 and 2, they are not turning up. When before the tribunal, they did not turn up. They are
Who is
also
1 and 2?
honor of the vehicle.
Owner and driver. Both owners.
So both are. Notice have been served, insurance company has entered the clearance, but 1 and 2, they are not coming.
So the direction is given to whom to pay.
Actually, it is a case fit for remand. It's a case fit for remand. Lordship kindly see answer 1, page 10. The two MSC cases were filed.
What order you are challenging? Page?
Page 10, my lord. Answer 1. Both claim case have been dismissed due to lack of evidence. After passing this order,
So it has been dismissed.
my lord, initially.
So
by
you
mistake-
want this matter to be remanded? 10,000 cost. As you are a claimant.
My lord, cost we have already paid. Once we have paid cost.
Where?
This my lord, the tribunal imposed cost of 500 rupees.
Okay.
We fight here, my lord, CRP by mistake. The honorable court directed us to deposit the cost first.
500.
500. We have deposited. Money receipt we have got. my lord.
So I put
Because
another
thereafter,
50.
my lord, the one,
No, so that 500, so it was very less cost it was imposed earlier, so we make it 15,000 each cost,
up to them.
15,000. If you want, otherwise I don't find any good ground, I should dismiss this petition. This type of petition should not be allowed. If you are not interested, there are a lot of other litigants who wants to fight and is not getting justice in the court. Because of people like you, these matters are getting delayed. Unnecessary. Why you have taken so many adjournments before the trial court if you are not interested? If you are agreeable, pay the 10,000 cost, then only. 10,000 here, 10,000, 10,000, 20,000. In two cases, 20, 40,000. Better off. Two councils. Or 10,000. They have to get the fees also. So that is why two appeals, 20, 40,000.
You're also. One was converted to appeal, my lord.
I am not concerned with all these things. You see, I'm telling you, Mr. Counsel, you have to understand. There are a lot of counsels who want their matter to be done. There are a lot of people who are suffering, not getting justice before the court because of the delay, because of people like you. It is absolutely an encourages litigation. This type of litigations cannot be allowed. be dismissed. My conscience does not permit to interfere with this type of orders. Go to the Supreme Court. Supreme Court may give you something. I am not going to give you. No, no cost business.
Cost may be given. Cost may be.
And no further adjournment.
Right.
I am fixing a date on appearance of parties on which date you have to file your evidence without any further. On that day, appear and file all your evidence on affidavit. There is no second or third time.
Right.
Matter was filed in 2020. Then our file.
Which one? From 14 on. No, from 16. From 16 till date, no interest. He won't be entitled to interest. Otherwise, he'll take the benefit of that interest in the no interest. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, appellant, and Ms. M. Chaudhary, who appeared on behalf of the
Respondent number 3.
respondent number 3.
This company.
Custom. The respondent number 1 and 2, however, has not appeared. So taking into account that the order which this court proposes to pass in the instant proceedings, the presence of the respondent number 1 and 2 can be dispensed with. First, the petition appellant hearing have challenged the order dated 4/6/2016, by which MAC case number 2340/2014 filed before the court of the additional district judge number 2 Kamrup Metro at Guwahati was dismissed on the ground that the appellant have failed to adduce evidence in spite of various opportunities being granted. The learned counsel for the appellant submits that the appellant is ready to pay such cost as this court may deem proper, this court may impose, as well as also has given an undertaking that the appellant would not take any adjournment for filing for adjournment in the said proceedings, except for reasons beyond the control of the appellant. He further had given an undertaking on behalf of the appellant that on the next date so fixed, the appellant without fail shall file the examination in chief of the witnesses. Ms. M. Chaudhary, appearing on behalf of the respondent number 3, had submitted that the accident happened
In 2014.
in the year 2014.
9.
Huh?
9/11.
9/11/2014. And on account of the delay, or on account of that submitted, that accident occurred in the year 2014. Thereupon, immediately the claim proceedings were filed. But in the circumstance, the claim proceedings is revived by this court, it would cause great prejudice to the appellant, to the respondent insurance company. Should the learned tribunal impose any liability upon the respondent number 3 insurance company? She submitted that the appellant herein is not entitled, should not be given any entitlement or interest with effect from 5/6/2016 till the date of the instant judgment. till the next date so fixed by this court before the tribunal, if in the circumstance this court is inclined to allow the instant appeal. So this court, having taken into account the materials on record and more specifically the undertaking being given by the appellant through its counsel, is inclined to interfere with the order dated 4/6/2016, but subject to certain conditions. Full stop. Accordingly, the instant appeal stands allowed with the following observations and directions. Number one, the order dated 4/6/2016 by which MAC case number 2340/2014 was dismissed is interfered with, and MAC case number 2340/2014 is restored back to the file of the Court of the Learned Additional District Judge number 2 Kamrup Metro at Guwahati. Number two, this court imposes a cost of rupees 10,000 upon the appellant, which has to be deposited on the next date so fixed by this court. On the next date so fixed by this court for appearance of the parties before the learned court of the additional district judge number so and so. The deposit of the said cost of rupee 10,000 shall be a condition precedent for the purpose of giving effect to the instant order before the learned court of the so and so. Number three, the taking into account that it is on the account of the fault of the appellant that the instant proceeding, that the claim proceedings have been delayed. The the appellant, the claimants would not be entitled to claim any interest, or would not be entitled to interest for the period from 5/6/2016 till the next date so fixed hereinafter. Next, this court taking into this court taking into account taking into account the above observations, fixes the matter before the learned court of the so and so on 14th May 2025. On the same date, the appellant is directed to file all their evidence examination in chiefs by way of affidavit. It is observed that if the examination in chiefs are not filed on affidavit or not filed on the date so fixed or any previous date before, the order dated 4/6/2016 stands restored. Above the instant appeal stands disposed. The second one you get, same thing, same order types. Itu agate M3 itu 10,000, 10,000. Oh, gitu. None has appeared on behalf of the appellant on call. It is further seen from the office note that notice have also been served upon the appellant pursuant to the order passed by this court on 19/7/2024. It therefore appears that the appellant is not interested in the instant proceedings. Consequently, the instant appeal stands dismissed for non-prosecution. IAK John? তিনিখন IAS. এখন IAS. The order dated 19/7/2024 passed in IAC number 2105/2024 also stands vacated. And the learned civic judge, junior division number 1, who is executed before whom title execution case number 03/2023 is pending. Junior division number 1 at Karbi Anglong, before whom title execution case number 3/2023 is pending, shall proceed with the execution of the said decree. Also, the registry shall intimate the instant order forthwith to the learned executive court.
And time being attempt.
Yes, you will withdraw?
Was the Lordship also for 49 is concerned, would like to withdraw it because, well, basically, there was a status quo order. In fact, the status quo order was made actually. So, my whole case is that, in the other case, where the 50 is concerned, I have been restricted from entering into my own premises. And in fact, we wanted, the facts period in the written statement as well in the objection, those were not taken into account. Only thing, I filed an affidavit in the additional affidavit in the other, in this item, second case, item 15. That is not on record.
No, in this case,
Item 49, I would like to withdraw. Because
FAO 11,
49, yes.
is it FAO 11?
Yes, FAO 11.
Mr. R. Day, the learned counsel appearing on behalf of the appellant, submits that he has instruction to withdraw the instant appeal. Accordingly, the appeal stands closed on withdrawal. I stands closed. Next.
Here,
The next one.
Before yesterday, I filed an affidavit, being on record the head interim
Next
intelligence.
matter. Yes, what is here first?
Here, the order, the interim order was not on record. I filed an affidavit on paper yesterday. That is not on record as well.
What is the order passed here?
Here, I've been restricted from entering into my own premises.
And in the earlier order also is same, no?
No. The earlier order, it was a status order.
Now here what do you want?
Here, my full condition was that, if the matter, the status order is passed, I have no other. No,
Where is the order of 21/4?
that is not on record, I have filed an affidavit, they have a statement, that is.
You have a copy of it, give it to me.
It ought to have been 23/2024. The order is wrong in that sense.
So here the order is in the result an order of ad interim injunction is passed, granted restraining to disturb the peaceful possession of the petitioner over the scheduled aliens. Now you say that you are in possession.
Yes. Now the problem is now they claim, it was an expiry order. They claim, that is what, in the objection, we said that we are in possession. Here the trial court, ultimately, determines the position.
And what does the learned trial court hold here? When you say that you are in possession?
The lordship only comes to similar, the only thing, they say that we did not say when we were disposed.
No, what is their finding?
Lordship then becomes.
They have not clarified the basis of their possession in absence of the evidence of dispossession from the disputed property. However, the opposing party did not specify the date of dispossession. You are saying that you have been dispossessed.
What has happened, my lord? The facts are quite different.
The opposing party have asserted that the OP number was dispossessed from the property by the petitioner. However, this assertion lacks. So here you say that you have been dispossessed.
Look, here, the
Page
pleadings are,
107.
the pleadings are quite different. The pleadings are quite different. Now, what has happened, my lord? He purchased a plot, 2 plots of land. Way back in, 93.
Let us see your objection. Where you say that you are in possession.
In fact, there is a counterclaim as well.
Counterclaim is okay. Let us see your objection that you are in possession. Where is your statement?
You will find it page 81. The text started page 5. Paragraph 5.
Finally come to page 85.
Yes. Now, this
That
is,
subsequently, the opposite party number 1, that is you,
yes,
got to know from reliable source that one labor has been kept there by constructing a house by one so and so, that is the present, and so has entered into the scheduled land, stating entirely that they have purchased. But this land belongs to the operator. Therefore, due to some personal difficulties and other people outside to look after the manager forestry executed area has been issued. Then when did you enter?
here, my lord, I was in position. What had happened?
No, the possession is gone here. You are saying.
Yes,
There is your own statement that possession is not there.
no, that is what the position, my lord, what has happened, my lord, the mediation case was pending. In fact, my lord, what
It's the day. Your own statement says that you are not in possession.
true, my lord, here, when the mediation was pending, my lord, they entered a, I could say, in fact, my lord,
So
what
they enter into a possession prior to
yes, prior to this order.
this order. So they are in possession.
As of now, yes.
Whereas you also therefore say that they are in possession.
Yes.
Now, how can you be allowed now to enter?
Their claim is on the basis of a, my lord, sale deed, which is not related to the land, my lord. They have entered my land. The question is, my lord, we have, in the counterclaim, my lord, we have sought for.
Anyways, we do one thing. We admit the appeal, call for the and issue notice. We'll see, look into this later.
The same other case, my lord, otherwise same facts. Only thing, my lord, in the other case, their status, there is a status order. And if there is a status order, my lord, I have no objection.
Why?
My lord, because, my lord, status quo is the only thing, my lord, they, if they start construction and if they, my lord, because there is a restraint order from
So here also you can very well file an application. That is what I told you. Order 39 will go.
the 39 rule could I thought that can be done. Yes,
But you can file that, but as of now, the court can either reject this or the court has, and today the court can only state.
True.
You are not seeking for an injunction because you are not
No, no, I'm
asking here.
only thing, my lord, only prayer is, you know, if the status quo is maintained, my lord, I have nothing.
But the status quo by this court would be passing an injunction in your favor.
That is.
So have you filed an order 39 rule 1 and 2 here?
No.
Why didn't you file it? Think you're playing to that affair. I need not say you are too clever out there.
In fact, my lord, I had just filed an affidavit bringing on record the, my lord, order as well as the, my lord, Jama.
No, that is okay. Now the question is, if you want any, then only I can pass a status quo.
Let it be next week, my lord. In the meantime, my lord, I'll file it, and in fact, my lord, the affidavit will also be on record.
Then I'll have to dispense with the notice and so in there. Okay. Mr. So and so submits that we may, that an affidavit has been filed in the instant matter. So the affidavit not being on record, list the matter again on when 26th. Don't grade you, huh? So you can file an order 39 1 and 2.
I'll go.
And don't forget order seeking waiver of order 39 3.
Order item 29.
Yes, what is this?
Honest, for the latest office note dated 28/1/25, we taken steps upon the respondents who are the legal hires. It transpires that two of the legal hires have also expired. And notice on respondent 4A and 4B has not been received back. Your Honor, in between these, our communication with the appellant also took place between us. And as per our last communication with him, he has directed that not to proceed with the case today, as a new set of counsel will appear on behalf of him on the next day.
In the office note dated 28/1/2025, it is seen. The respondent number 1A and respondent number 6 have expired. Counsel appearing on behalf of the appellant shall take technical steps.
30.
Service complete? Service complete, LCR received is the matter for hearing in the usual course, liberty given to both the parties to file application for early hearing. Advised. Insufficient address.
Yes.
You don't want to pursue again respond number 1, 2, and 3.
But
So we strike out their names, you don't know their names.
I've taken the steps as per the addresses which is mentioned in the suit,
Very good.
but it has.
CRP, what is this CRP business? Let us see. You can dismiss it, you don't need to take steps.
Always also.
What are you challenging?
Nonsense. You're challenging the order details. 10/3/2023 and 4/2/2023. Which the civil judge as well as the munshi has dismissed our injunction application.
You have not been able to serve upon the respond number 3, 1, 2, and 3.
But cause this is showing someone's name.
Huh?
Cause this is showing someone's name.
And names have been shown.
Yes, one and one there. SA.
It's so. There's no wakalatnama.
Wakalatnama is
Then office note with the address and police. No wakalatnama. Insufficient address. What address you have given? Let us see. Can there be insufficient address? Oh, yes. This is insufficient address. Why have you given insufficient address, Mr. Counsel?
the suit also is same address as the petition. At 860.
What about this? Linkage number 3? What is the address?
Painting number 3 is
Resident of quarter number 165, Goboru Pathar, Railway Colony, PO Goboru Pathar, so and so. Now let us see the address of whom?
plain is at page 60.
We are concerned with 1, 2, and 3.
120.
You are the plaintiff.
Yes, I'm the plaintiff.
You have not been able to serve them. Then,
I'll ascertain the correct address.
same order I am not extending. Taking into account that service have not been completed, but the petitioner have not been able to take service upon the respondent number 1, 2, and 3. This court is not inclined to extend the interim order passed on 2/6/2023. liberty is given to the petitioner to effect service upon the respondent number 1, 2, and 3 by way of the state, routed to the registry of this court and file an affidavit of service on or before the state. This is the matter on 19th of May 2025. On the same date, upon service being duly effected upon the respondent number 1, 3, this court shall consider the interim plan.
33,
Answer. Who wants to go where?
Service is completely lost from Dimapur to Karimnagar.
Where?
From Dimapur, Nagaland.
From Dimapur to Karimganj. Why?
The petitioner is the defendant in the Mali.
So you're making the state of Nagaland a party? Money suit.
Yes.
Why should we? Who has filed the suit?
Is the respondent number 2. Money suit is filed by respondent number 2.
And why you're making the state of Nagaland a party? Huh? Isn't it the suit at page 19?
Yes, Your Lord.
And what is this? Ubabuddin Bal Wahid, aged so and so son of Aya. Who is he?
The owner and proprietor of this.
So
That's a
the
wide
plaintiff,
group,
the plaintiff, you are the defendant.
Defendant.
So this group has to come.
Yes,
And who is he? Nobody.
the owner of the suit.
So it has to be mentioned so and so, the owner of so and so. But that the defendant is not here. Some other person has come. And why should we transfer? What is the reason?
For carrying your lawsuit.
No, hearing is down. Transfer reasons are like this. No case. This is a money suit. Who? What is your problem?
Respondent 2 also appeared on the last occasion and they are supposed to file the objection. Your Lord.
Oh,
Respondent 2. Your Lord.
not necessary. I don't require any objections. Whatever objections are not there. What is your fear in going there? You are not going to appear. Why? Hostile circumstances. What is the hostile circumstances? The lawyer will go. Oh, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. None has appeared on behalf of the respondent. There is an application filed under section 24 of the Code of Civil Procedure 1908 for transfer of money suit number 14 of the 2023 pending before the court of the learned civil judge, senior division Dimapur, Nagaland, to any other court of competent jurisdiction which in the district of Karimganj or in Kamrup Metro, Assam. This court has duly taken note of. The suit has been filed by the respondent number 2 against one MS Wahid Group and Co. with the address situated at East Bazaar, Karimganj, Assam 788711. However, it is seen that the petitioner herein is not the defendant. The counsel appearing on behalf of the petitioner though submits that he is the owner of MS Wahid Group and Co. But in the opinion of this court, it is only the defendant who would have a locus standi for filing an application under section 24. On this count alone, the instant petitions ought to be required to be dismissed. Additionally, this court has also taken note of the grounds assigned in the said application. And in the opinion of this court, that the grounds mentioned and are totally misconceived for the purpose of misconceived without any materials being brought on record that there is a hostile environment.
Para 6
Apart from that, the petitioner can very well participate. The defendant can very well participate in the said suit proceedings through their advocates and there is no requirement to the advocates. Considering the above, this court finds no justification in exercising the power under section 24 of the Code of Civil Procedure 1908 for transfer of money suit number 14 of 2023. The order dated 27/3/2023 stands vacated. Your file written statement?
There.
File written statement. Stands vacated. The parties are directed, the petitioner is directed to appear before the learned court of the civil judge, senior division, Dimapur, on 15th of May 2025. And on the same date, the written statement be filed without fail.
Right.
Service completely. LCR received is the matter for hearing in the usual course, liberty given to both the parties.
In regard to item 32, the council has appeared. 32.
Who is 32?
32.
You are appearing? Oh, tell me. Oh, very good. You are appearing. But we have vacated the order, na?
Yes.
Good. You have filed a wakalatama. You got hold of some counsel who doesn't know, he will tell about the matter. Well, help it. Where did you get her?
That's
Did
outside.
she sign any wakalatama? Have you signed wakalatama? You don't know.
He says that her senior is appeared.
Oh, then you get hold of anybody. You may ask Mr. R. Goswami also to appear tomorrow somewhere in other matters. Some senior was appearing some years back. This type of matters. We have vacated the order, no? We have fixed it, we have taken. Let them construct for some time. That
35.
34, service complete.
35. Number 35, my lord. I am in deep trouble, my lord.
Why?
My lord, because, my lord, in the year 2015, the respondent number 1 died, my lord. Respondent number 1 died, my lord, the decree holder filed an application for substituting the legal heirs of the, my lord, respondent number 1, the ZD number 1. However, my lord, there is no order to substitute the legal heirs of the ZD number 1, my lord. The appeal, the execution petition, which I have annexed, my lord, it does not show, my lord, the legal heirs were substituted, my lord. I have checked the order, my lord.
No,
Notice
the
is,
judgment debtor is dead.
one is dead, my lord. Who is alive?
Huh? There's only one. There's only one. In your petition, page 4. The other is performer. I don't understand how can there be a performer judgment debtor?
My lord, that is my mistake, my lord, because in the suit, my lord, he was performer, my lord.
So,
But
he's not a judgment debtor.
he is judgment director in the, my lord, execution petition.
Maybe,
That
but
is my
performer.
mistake.
Anyway, don't make him. Anyway, he's dead.
He is dead, my lord.
And he died when?
2015, my lord.
And you filed the death against the dead
That
person.
instruction I did not have because, my lord, in case execution petition, now I have prepared the substitution application. Today I have checked the record, my lord. That was, my lord, informed to the learned court, executing court. So I need 2 days time to, my lord, file application order 1 rule 10.
How?
Yes, my lord, the execution, in the execution proceeding, my lord, the decree holder has informed the honorable court that my lord, ZD has died.
Then?
ZD number 1 has died.
Yeah.
But there is no order to substitute the legal heirs of the, my lord, ZD number 1.
Where?
In execution proceeding.
Very good. Don't execute. Not necessary. No.
But-
You are paying.
Number 2.
What does he have? Nothing. You are also a judgment debtor. What is the decree pass?
The exception has been filed jointly. That's why the factors of judgment, the recovery of possession against the defendants.
So against you also.
Tell him, my lord, 2 days time, my lord. I
What are you challenging?
challenging, my lord, Here, my lord, this JD 1 and 2 file an application for under section 47, my lord.
Hmm.
That is the execution proceeding is time barred.
Who filed?
JD number 1 and 2.
Then
My lord, my execution proceeding has been dismissed.
why?
It's time barred.
When was it filed?
Accordingly, my lord,
When was the judgment passed?
Judgment was in the year 2001.
And appeal?
Appeal also.
the
Second
trial
appeal
court judgment is, my lord, 31/7/89.
Then
First appellate court, my lord, 12/8/94. Then second appeal dismissed. Both the three decrees are in favor of me, my lord.
it's
Fir-
okay. The second, the third one is of 2001.
2001, my lord.
Then,
First appellate court allowed 3 months time.
and when did you file?
I have filed, my lord,
30.
13,
Huh?
11, 2000, 25/9, 2013.
25?
9, 2013. Yes.
And the High Court, the High Court's order is of 14/8/2001.
One.
Then obviously,
My lord,
but
the first appellate court, my lord, he has said that, my lord, the decree can be 40 days time to vacate the supplant, my lord. My lord, my right to accrue to file the execution proceeding in my humble understanding, my lord.
no, whatever may be. Your decree has been affirmed on 14/8/2001.
14,
Okay.
2001, my lord.
You filed in the year 2013.
2013, my lord.
So obviously it is more than 12 years.
But one
Even
month,
if we take for the 40 days.
my lord, that is, my lord.
Then-
That is how you lost me another date, my lord.
No.
Kindly
matter
one
dismissed.
date, my lord, kindly one date.
Matter dismissed. This type of cases don't spoil your time.
But
Matter dismissed.
kindly one date, my lord.
Why?
My lord, I will, my
Okay,
lord,
Lord Counsel.
bring on record.
That is why you didn't get anything.
Bring
This
on
type of
record the
matters
alarms
is
of
spoil
the
you.
decree number 1.
Okay, tomorrow at 2. One day, tomorrow at 2. We dismiss
Day
it.
after two. I will file
What?
an application tomorrow, my lord.
The council upon hearing the matter has sought for adjournment, placed the matter on 21st March 2025 at 2 p.m. with a cost of rupees 5,000.
First, may not be.
5,000.
But
Really?
tomorrow.
Tomorrow? Do the matter tomorrow at 2.
36.
Okay, done. What is this matter? PRP? For what?
By the municipal injunction order, they asked for temporary injunction that rejected. Then the civil judge also rejected their injunction. And now they're in the high court. They want to stay the financial irregularities done by the petitioner, by law.
Financial?
Irregularities done by the petitioner, and they want to stay of that by law.
No, why is the suit stayed?
Suit is stayed by.
Why?
I don't know, by law.
Why is the suit stayed?
This matter I'm led by Mr. D. Das.
Who is Mr. Didas? Senior advocate. Senior advocate, I don't give adjournments.
Today he's unable.
No, but tell me, under what authority or what authority a suit is being stayed? Tell me,
We have challenged. the
can a
order of
suit
the-
be stayed in an injunction proceedings?
And then granted the injunction by law.
It is absolutely means what I have means, what do I say? I'm sorry, Mr. J. Roy. This type of orders are being passed.
Lordship Not much aware of the order, Lordship. They-
What? Okay, tomorrow at 2.
Much obliged, sir.
Husband, wife, where do you want to go?
From Tezpur to Guwahati.
You want to Tezpur to Guwahati? You?
Please put your lordship.
Why? You are the husband?
I'm ready to pay the expenses. The allegations that she has made in the petition, your lordship, are not true. She can very well move from Guwahati to Tezpur, your lordship.
You do one thing, you pay him when he comes here.
Coming, the petitioner has already instructed the case under the domestic violence case, Your Honor. He is regularly appearing in Guwahati. And no maintenance order. was-
What business does he do?
I'm an interior designer here, Lordship, as on it, but my business.
And the petitioner is not working with you, na? She is completely dependent on her tenancy.
And he's going to pay. You see, you don't need to go every day in the Silcha in Tejpur. You only appear through your lawyer. It is only in the case here he has to come every day. That is the only worry I am saying. You do one thing, you go to Tejpur every day. Whenever you are required, you go. Otherwise, lawyer will appear. You don't need to. You can file application for internal all these expenses and all. And every time they will pay 4,000 when you will give. That's over. Amount is 4,000 whenever she.
Very grateful, Your Lordship.
And both of you have not filed your written statement. Go and file the written statement on 13/5/2025 before the trial.
Very good.
बहुत हो रहा है।
38,
Yes,
Please, your lordship,
what is the service? The phone number 1, 4, so and so, service, so and so. Service not done.
Respondent number 2 has expired. So our legal hairs are already on record.
But many have not been done anything, no? You do one thing, let me place this matter before the laws of court. You go and explain to them what is to be done. Okay? So taking into account the office note dated 28/1/2025, this court directs the registry to place this matter before the laws in the court. The council, appearing on behalf of the appellant, shall appear before the state court and decide as to what are the things is required to be done.
39,
Not the topic of the.
What? You are paying for whom?
I am paying for the 1, 3, and 4.
Phone number 1, 3, and 4. You're paying.
39,
Service is properly looking. NCR was not called for. NCR should be called for. Why? Because of the evidence. Evidence have to be looked into also because also the plaintiff evidence, which was dismissed and appeal was allowed. And thereafter also the second appeal.
Service is complete. However, taking into account the substantial question of law formulated by this court on 10/6/2024, the records of the learned trial court as well as the learned first appellate court will be required. The registry shall be the needful. We shall call for the sake of the records and place the matter for hearing immediately upon receipt of the.
Obliged.
It will be given to both the parties upon receipt of the records to file petition to the legal.
Obliged.
Service complete. Service complete.
I'm not sure, but as for 2A, Monoration has expired.
Phone number 2.
2A or not.
You know when
6/12/2020.
you were earlier appearing. You were earlier appearing on behalf of respondent number 2A. Respondent number 2A has filed wakalatnama. Were you appearing earlier for respondent number 2A by filing wakalatnama? This is what I'm asking. Mr. So-and-so, the learned counsel, who was earlier representing the respondent number 2 by filing the wakalatnama, had submitted that in terms with Order 22, Rule 10A of the Code, the respondent number 2A expired on
6/12/2020.
6/12/2024. Full stop. Taking into account the above, this matter on 2nd of April 2025, Mr. So-and-so shall provide the names of the legal representatives of the respondent number 2A to the counsel for the appellant on or before the next day.
We filed the substitution petition, but that has not been tagged with the.
Oh, you filed it?
Yes, Lord. But
Very
that
well.
has not been tagged with the record. Lord.
It is 2A, it has a for the 22A, the 22 penny informed that he has expired on so and so. Mr. Counsel, appearing on behalf of the appellant, submits that the due substitution applications have been filed, however, the same have not been placed on record. The registry shall bring on record those substitution applications after 2 weeks. You don't need to furnish, he has already filed.
41.
LCR having not been received, the registry shall take effective steps in that regard.
We have wrongly filed an IA, madam.
Where?
3948/2024. And are claiming 50%, but 50% already is given in another IA, madam. That was out of my lot.
Yes, Sigdal submits that she would not like to press IA Civil 3948/2025. Taking into account the above, the instant application stands closed.
Must oblige now.
IA upon IA 3948/2020. এই তো withdraw করেছি। What is this contempt? 42. What is this contempt? And why am I doing with a contempt?
Is 27. According to them, we haven't paid.
Oh, where's the other side? 27. General manager application for payment of unpaid amount of rupees 3 as per direction of so. What is this? 39,419.
Possibly this is not correct. You will see the next page.
3,19,000. It is also 39,419. Isn't it? Something is wrong anyways.
Something is wrong. It should be 3,94,000 and all.
Okay, then what happened?
So they want to say this amount is not being paid. I wanted to get the feedback from my client, but till date, I don't have any.
Take the feedback.
Beg your pardon.
You take the feedback. Mr. Dr. The senior counsel appearing on behalf of the sole respondent seeks some time for obtaining instructions and filing affidavit in the matter. This is the matter again on 26th of May 2025.
43. Part 38 of the real estate development authority. We are asserting the. order
Understood why the matter has come here in orders.
Not admitted, but for the first time it has come to court.
It should come up for admission.
Lost.
So this is matter for admission in the first week of April 2025.
44.
Who wants to go where?
You think transfer from because
Oh, new matter.
Silchar
You
to
want to go
Vishwanath.
from? Did not have the jurisdiction to entertain the petition filed by AR seeking divorce on the ground the marriage was solemnized between the petitioner and respondent at Guwahati. Both resided together at Baheli, Vishwanath, and petitioner who is the wife is a resident of Guwahati. And this was filed next week.
We have no objection regarding that, she is a resident of Vishwanath Sareli, but we have objection regarding there is a last resided together in Vishwanath Sareli. So it may be transferred, Your Honor.
But taking into account A2, and again, text the paragraph 5 to 2 so taking into account the provisions of section 7, 19 of the Family Code Act. Hindu marriage 1955. Which stipulates that the jurisdiction to file any proceedings under the said act would be where the marriage was solemnized or where both the husband and wife resided, last resided, or where the respondent, where the wife was residing, if the wife is the defendant, would have the jurisdiction. Taking into account that in the instant case, the marriage was solemnized between the petitioner and the respondent at Guwahati. They resided together, last resided together at Behali, Biswanath, Karyali, and the petitioner, with the wife, was a resident at Behali, Biswanath, Karyali, the court at the principal judge, family court, Kachar, did not have the jurisdiction to entertain the. What case is this? Divorce. The divorce proceedings registered as FC civil case number 542 of the 2024. Was taking into account that the petitioner herein have sought transfer from this court, transfer, and the respondent, the petitioner herein have sought transfer, and the respondent, who is the plaintiff, have no objection to the same. This court transfers the here plan transfer to the court of so and so. The petitioner will file their written state next date fixed for appearance on 14th of May 2025. Petitioner shall file their written statement.
Public.
Survey is not complete.
Whether the respondent number one was a non-contesting defendant in the title suit and even in the first suit. Whether the respondent.
You are being what?
2-1, 2-5, and 3-6. 2 series and 3 series.
Respondent number one was, cannot be, we can't strike off.
It's the recorded trial court as well as the appellate.
Then what to do? If he wants to strike off, he strike off at his own risk.
Then one opportunity may be given.
Counsel appearing on behalf of the appellant submits that he would like to take first steps upon the respondent number one. So he may do so by way of registered post within 7 days from today. This is the matter again on 18th of June 2025. The respondent and the registry shall bring on record the note as to whether service upon the respondent number one is complete.
46.
Phone number? अभी तो बोल रहा हूँ
Register of this application today.
no, today.
Dispose of this application today.
No, these types of, that is why these type of matters are immediately I finish it off, because unnecessary staying the suit would have any. The next date is 6th.
In the month of April.
When is the next day?
3rd May.
3rd of May. Urge Mr. A.K. Pulkashkar, the learned counsel appearing on behalf of the petitioner. And Tansuti, the learned counsel appearing on behalf of the respondent numbers.
All respondent.
On 1 to 4, 1 to 4. The instant petition, the supervisory jurisdiction of the court has been invoked. Challenging the order dated 21/11/2024.
Madam, Lordship is going to dispose of the matter.
Yes, I'm allowing your petition.
Madam. Yeah, my lord, only one myself, listen.
All these, whatever he submits, that will, if he when appreciated, will be. If you want to put objection, appreciation will be done in accordance.
My lord, allow only two things, right?
Yes.
One thing, my lord, they have in their fix that order without following the procedure, without following the rule 16, they should have given the notice to preview before filing the application under order 11. Next, my lord, they have paid the electric charges up to the March 2019, and they have not disputed that. When they have not paid the electric charges from the month of March 2019 to onwards, then I filed a case for rejection on the ground of that default that they have not paid the rent and as well as the electric charge. Electric charge is the part of that. Now they want to say that the electric charges, which I want to realize from there, from the month of April 2019 to May 2020 is not in accordance with the rate decided by the FDCR. But they are not paying by the electric charges. Till today, my lord, they are not paying the electric charges. From April 2019 to till, my lord, they are enjoying premises without paying the electric charges. And they are filing the application one after another. It was fixed for procedures and they also were. There they did the rest. They are only.
What is the stage of the suit?
State of the suit is correct for process. For process.
Of
Of the PW.
PW1.
Yes.
Now he want to adduce evidence of these documents.
They want.
These, which documents?
They want the copy of the electric bill of the main bill from the month of April 2019 to 2000. May 20, my lord, they want. Then there is a submitter, installed in the community premises.
So these are the documents they want to exhibit. You see, kindly see, come to the exhibitor evidence on affidavit,
Yes, of PW1.
PW1,
Yes.
page 49, exhibit 4 to exhibit 22. This is what they want to exhibit.
Is the exhibit which they want to produce, whatever bill and land receipt is provided to us. This is not the original copy of the electricity bill. They are saying electricity bill is a part of rent, my lord. So whether the charge, my lord, the electricity, my lord, rate they have charged, whether it is inconsistent with the rate, my lord, provided by the. by the-
And if the plaintiff to produce the original
So we want to
electricity bill
determine.
for the title of the plaintiff issued by electricity official from April to May to now. So he wants this. No, first of all, you have it because the plaintiff's, it is the plaintiff's meter, you have it, these documents?
Yeah, I have.
Okay, so next date, you produce this.
Okay, but I said, but.
No, you see, Mr. Consitin, let us not go into complications. Trial court should be more simple.
And one of the pending is a longer time.
Okay.
The time
So,
taking-
it's an application filed whereby the order dated
The procedure.
order dated 21/11/2024. Passed in title suit number 79/2020 by the court of the learned civil judge, junior or senior?
Junior.
Junior division number 2, Kamrup Metro at Guwahati. Hereinafter referred to as the learned trial court was have been assailed. This is the present application has been filed. invoking the supervisory jurisdiction of the court, to assail the order dated 21/11/2024, passed in titleship number 79/2020 by the Court of the Learned Civil Judge, Junior Division Number 2, Kamrup Metro at Guwahati, hereinafter referred to as the Learned Trial Court, whereby the application under Order 11 Rule 14 of the Code of Civil Procedure of the Code of Civil Procedure 1908 was rejected. Full stop. This court have duly perused the application so filed under Order 11 Rule 14, which have been registered as petition number 2401 of the 2001, whereby the plaintiff sought for a direction upon the who filed this? The defendant.
Yes.
By the defendant filed sought for a direction from the plaintiff for production of the original electricity bill for the meter of the plaintiffs issued by the Electricity Department of the APDCL from April 2019 to May 2020, and thereafter till date in relation to electricity provided on the suit premises. The it is seen that the plaintiffs pursuant to the said application filed objection stating inter alia that the manner in which the application was filed was not in the proper format and accompanied by an affidavit. The learned trial court rejected the said application on the ground that the defendants had not raised the issue at the time of document production, during the documents stage, or through interrogatories, and their request for production of the APDCL bills at this stage is premature. At that stage was premature. It was further mentioned in the said order that there was no necessity for the plaintiff to produce the original APDCL electricity bills, as the electricity charges in question were based on the readings of a submeter installed for the suit premises. Mr. Ansuti, is it your place that the electricity charges is a part of the rent? Whereas they say that the electricity charges is not a part of the rent. Yes. So the page 36, they say, since the electricity charges are not part and parcel of the rent, hence non-payment thereof cannot be termed as default in payment of rent.
But When it is received will show, my lord.
Huh?
When it is received, it will show that it is the part of that. What is March 2019, they have not disclosed. Whatever bill was raised here. Now, from April 2019, till today, they have not paid any. Yes, no, earlier in my pen, in my minutes.
No, Mr. Bukasta, why do you need the electricity charges, the bills?
But my lord,
Why do you need the electricity bills?
because they are saying it is a part of rent, number one.
No,
Number two, that-
understood. If it is a part of the
Right.
rent or not, how is the electricity bill sent to them?
We are saying, my lord, since it is an access charge now they have made. Because the rate which was prescribed by the electricity board, you cannot go beyond that. Therefore, we stop paying, my lord. Moment we have come to know they are charging more, then we will stop paying, my lord, electricity bill. Whatever they are charging, we stop paying. We are saying you cannot go beyond the rate which was prescribed by the SCT. They are charging, my lord, electricity charging, my lord, 9 rupees per unit. They are charging more than 9 rupees. Therefore, whether it is within their competence to charge any rate, my lord, other than, my lord, beyond the rate prescribed by the electricity board. And they are saying, that since there is a.
So
my
why
lord,
do you need therefore the entire bill?
Yes, but for that period.
No, understood. Why do you need the entire bill?
And tell me, my lord, we want to examine that, my lord, because electricity bill varies from time to time.
No, you have not paid the electricity bill after May 2020.
Yeah, right.
So you can only limit yourself for the May, from April 2019
Right,
to May.
right.
You are not asking the others. No,
No.
but there is a prayer being made.
We are
You-
asking
you
my lord,
have it,
only, my lord, April 2019 to May 2020.
No, because and thereafter till date, that is not required.
That is not required.
Last time, too. This court inquired with Mr. Substitute, the learned counsel appearing on behalf of the respondents herein, who are the plaintiffs, as to whether they have any difficulty in producing the electricity bill issued by the Electricity Department of APDCL from the month of April 2019 to May 2020 in respect to their premises. Mr. R.C. Sansiti submits that there is no, that the plaintiffs have no objection. Consequently, this court further inquired with the learned counsel appearing on behalf of the parties as to when is the next date fixed before the learned trial court. It has been submitted that the next date is fixed on 3rd of May 2025. Accordingly, this court directs the respondent herein, were the plaintiffs, to produce on that date the originals of the electricity bills from the original electricity bill for the meter of the plaintiffs issued by the electricity APDCL. I think APDCL, electricity distributor of the APDCL from month of April 2019 to May 2020. Upon such production, the learned trial court shall pass appropriate orders in that regard. With the above, the instant petition stands disposed, the in order passed earlier.
Obliged.
Sincerest apologies, my lord, in regards to item 45, my lord.
Item
45, my lord. Can it be fixed on an earlier date because it pertains to an injunction matter already constructed?
45, what has happened?
My lord, the date has been fixed on 18th of June. My lord, can it be fixed on an earlier date?
Why?
Because it pertains to an injunction matter, my lord. Construction is already going on.
It's an RSA.
Yes, my lord, and I has been filed.
Okay. It will be on 21st of April.
Either 24th or 25th. My lord has consulted with the others of
Okay, 25th of April.
April. But
Item number 47, what is this? Review?
it is a review of the judgment order dated 24/10/25 of lordship, done by the honorable court in contempt case 557/23.
Who by? I pass.
Yes.
What did I say? What is the IA for?
I have a condemnation.
Huh?
Condemnation delay of 113 days in filing the review.
I didn't pass the order.
Lordship may
Whose order are you saying?
case number 16, your lordship.
The instant contempt petition has been filed alleging violation. Then what I did?
The lordship had disposed the contempt petition.
What further steps have been taken by the circular in pursuance to the order? If the contempt petition be served upon and be submitted as well and so. And what are the reverse? Regard here placed before this court and instruction is to along with the view of the order has been complied with. Instant petition is then drawn. Then what I mean?
Lordship, one time mediation case has still not been completely disposed, your lordship, by the circle officer.
And what is this IA? Why the matter gone up before any other bench?
Lordship, we had actually, after the contempt was disposed of by the honorable court, we filed a fresh.
Okay, leave this matter. Leave this matter again on 6th of March 2025.
Obliged.
Okay, leave on, guys. Yes, what are they? 50? Huh? Who?
He will do that, he's going to tomorrow.
So what? Get any other counsel?
Friday, please.